All right. I'll remind everybody to make sure your phones are off. Now, ladies and gentlemen, jury duty may be strange to some of you, so short explanation is in order. Those who participate in a trial must do so in accordance with established rules. It's true of the witnesses, the lawyers, the judge, and jurors. The lawyers will present the evidence according to the rules. The judge enforces those rules and determines what evidence may be admitted. Now, as a jury, you will be the sole judges of the facts, credibility of the witnesses, and the weight to be given to the testimony. And at the end of the case, the court will instruct you regarding the law on that, and you'll apply that to the facts. It's your sworn duty as jurors to accept the law as is given to you by the court. Now, the procedure for the trial will be as follows. First, the attorneys will outline what they expect the evidence will be. It's called opening statements. They are not evidence, but are a preview of the claims of each party designed to help you follow the evidence as it's presented in the case, but it's not evidence. After that, the state will offer its evidence. Upon conclusion of that, the defendant may, but is not required to offer evidence. If the defendant does present evidence, then the state may, but is not required to present rebuttal evidence. After that, the court will provide instructions on law regarding the charges. You'll hear closing arguments from the attorneys, and then the instructions on the law about deliberations, and then you'll retire and deliberate on your verdict. Now, procedure for questioning the witnesses is as follows. First, the party of the called, the witness, will ask questions. That's called direct examination. And then after that is concluded, the opposing party may ask questions. That's called cross-examination. After cross-examination is concluded, then the party that called, the witness, may, not required to, but may ask additional questions. That's called redirect examination, and that's limited to matters that were raised on the cross-examination. Jurors are not permitted to ask questions. Now, during the trial, it's likely the attorneys will make objections. An objection is a procedure by which an attorney raises a legal issue that must be decided by the judge. And then I apply the rules of evidence and the statutory rules and other procedural rules that apply in the case to determine what ruling should be on that objection. Now, if the attorney objects and the court makes a decision that either the question or the likely answer or both are improper, then I will say sustained. And that means that the question cannot be answered. If I say that it's overruled, then I've determined that the question and the likely answer are both proper and can come into evidence. Now, during the course of the trial, it's not uncommon for an answer to be given before an objection can be made or while the objection is being made and the witness answers the question. If the court determines that that question or answer were improper, then you'll be instructed at the end of the case, and perhaps even at that time, to disregard the testimony. If an attorney asks the court to strike and I say it's stricken again, that means that it can't be considered. Now, we all know that you're not computers. It's not like the computer where you can just delete it. It's gone off of the screen or whatever. But the way that is enforced is that if during deliberations somebody brings up an answer that was made that was stricken, and say, well, yeah, we heard that, but we can't consider it because that was stricken, or the court, sustained the objection. It's important that you be fair and attentive through the trial and listen to everything that's going on. During the trial, I've already explained this a little bit to you, but I'll go a little bit more into detail, and that is that you're not to discuss the case with anyone among yourselves or with anyone else. If you are a person that likes to text or tweet or whatever it's called now, or other types of social media during the day, you can do that as long as you don't do it about this case. So what I tell people is don't even put out there that you're on a jury, serving on a jury, because somebody might say, that's the such and such case, and that person blah blah blah, and then you'll have an issue that it was unnecessary. So after the trial's over, you can post all you want if you want, if you desire to, and if you don't desire to, that's fine too, but don't do that during the trial. Now, it may be a little more difficult to understand. Let me back up. I skipped over something. You're also not to form or express any opinions on the case until it's finally submitted to you. Now, I understand as humans, when you're hearing something, you have first impressions, and that's a human reaction, and obviously that will be the case. However, don't form any solid opinions, because you'll discover, as I have over my career, is that first impressions are not always the ultimately correct impression. And so any opinions that are to be reached are to be reached only after the case is concluded, which means all of the evidence has been presented, you've heard the arguments of counsel and the instructions of the law from the court. And then at that time, the opinions are to be expressed. Now, that includes among yourselves. And some jurors may say, well, why can't we talk about it during breaks and so forth since we're the jury? Well, again, it's because until you have everything in the case, all of the evidence, the arguments of counsel, the instructions of the court, you don't have everything that's necessary. You don't have all the pieces of the puzzle to put it together. And so you're not to discuss it during lunch breaks or during breaks in the jury room, or if you're walking, taking a walk or something during a break, do not discuss it. Also explain this to your family and friends if you are in communication with them during breaks. I know there have been cases where people have said, well, when I told my family I couldn't talk about this, they said, well, I was on a jury and I could talk about it. Well, that may have been the case, but it was after they were done with the verdict. Our memory sometimes fails. But during the trial, can't talk to anyone. After the trial, talk to anyone you want or not. That's up to you. Now, if anyone should attempt to talk with you or say anything to you, or if you might inadvertently, while you're out during breaks, hear something about the case or something of that nature, overhear something, then you should report that to the bailiff, and then the bailiff will report it to me, and I'll consult the attorneys, and we will discuss what might happen. Now, and this also applies to, let me go on before I follow up on that, and that is this. You're not to investigate or attempt to obtain any information on your own about the case. To do so is improper. So, a lot of times people want to, during a break, want to drive by the scene of the alleged incident or something of that nature. You're not to do that, or to look up anything online about the case, or anything that you hear during the testimony. So during the testimony, you may hear a testimony about a subject, and you're thinking, well, I've heard about that, and I think that might not be right. I think I'll look that up. Well, you can't do that. Whether it's right or wrong has to be determined from the testimony, the evidence, and from no other source. For that reason, you're not permitted to read, view, or listen to any reports that may be online. Used to be it was just TV and radio and newspapers. Now it's on the internet often, and we do have this on YouTube, so reporters or other people can watch it and post. But so if you do check your social media, or you go online to read a news or something, read nothing. Don't read anything about this case, because again, impressions of others that are posting online or reporters that are writing stories. They're not under the same duty that you are, which is to decide the guilt or innocence based upon the law and the evidence is submitted. And so, therefore, their accounts are not to be considered, should not be read at all. Now, with regard to that, as well as if there's any thing that's said or contact with anyone about the case that occurs inadvertently, I indicated you must report that to the bailiff. The same thing if something like this were happen where you were inadvertently exposed to something. You tell the bailiff, and then I will discuss it and talk with the attorneys. Sometimes that requires that we bring you in and ask you some questions to make a determination if you can continue to serve as a juror. Now, one of the cautions that I learned the hard way when I was an attorney probably 40 years ago is, and so it's the reason I tell you this, if something happens during one of the breaks and you come back and you're not sure whether you should say anything to the bailiff or not, don't ask your other jurors what their opinion is. Do you think they'll have to do this? And the reason for that is this. I had that happen about, and it's probably 35 to 40 years ago. I was prosecutor. We were in the middle of a 3 or 4 day trial. Had 15 jurors. We had 3 alternates, so I know it was a long trial. And that happened, and the juror came back at lunch, and after the other 14, as they came in, they started talking and saying, what do you think? What do you think? So guess what? We spent that whole afternoon interviewing 15 jurors to decide whether or not what the report had been or what the information was about had any bearing on whether they could continue to serve. As it turned out, they all 15 were okay. We wasted an afternoon doing it. So that's why I say, if you have any doubts, tell the bailiff, but don't by any means bring it up to any of your fellow jurors. Now, from time to time, you'll see bench conferences like we did earlier this morning when we selected the jury. When that occurs, they come up to the bench, we discuss things. A lot of times it's just logistics, like how long the witness is going to take, when we're going to take a break. Or it could also be, sometimes, as I indicated, when there's an objection, there's an argument about the law. And sometimes that's necessary for the court to hear what the proposed answer is going to be. And rather than do that all in front of you, where then I have to tell you if I say it's not admissible to forget it and not use it, we just do that so that you're not hearing something that you ultimately may not be permitted to hear. That way it keeps you from having an additional burden of trying to set aside things when you deliberate. Also, there are no note-taking may be done by the jury. This is a short trial. When I have longer trials, I will allow note-taking under some certain restrictions. But the reason I do that, and most judges do it, and my personal example is this. Way too many years ago, when I was a freshman at Ohio State from Hillsborough and went up to a campus of 47,000 people, and I was in my first class with 200 people, and the lecturer was talking, I was writing down every single thing. And then after the first couple of days, I realized, number one, all this stuff, a lot of the stuff is just preliminary things, and I was starting to miss things that might be important. And so my attention was distracted. Now, it takes a few years to learn the discipline to listen and write at the same time. You see me doing that. That's a necessity for an attorney. But for jurors that are not involved in that on a regular basis, it can pose some challenges. And so that's why it's under certain restrictions. But in a short duration trial like this, note-taking is permitted. All right, so with that, we will now proceed with the trial. The next phase is the opening statements of counsel. They will give you their preview, if you will, or outline of what they think the evidence is going to be, but they're not evidence. State, Mr. Collins.
Your Honor, can we ask for separation of witnesses?
All right. If there are any witnesses other than the state's representative, Lieutenant Antonor, that are present, you're required to be outside the courtroom during the testimony and not to watch or listen to anything on YouTube about that. And you'll have to take care of it. I don't know who your witnesses are. So.
Okay.
Right, you may proceed.
Thank you. May it please the court, counsel, ladies and gentlemen of the jury. Today the state will prove that this defendant, James Gregg, raped Nevaeh Penwell many times over the course of the past 4 years. James Gregg and Dorothy Mooney have been married for several years, but they've also been separated for several years. Nevaeh is Dorothy's daughter, and James has been in Nevaeh's life since she was only 3 months old. Nevaeh calls James daddy. And up until February of this year, Nevaeh spent almost every weekend at her dad's house. Nevaeh was born in December of 13. So in 2022, Nevaeh was 8 years old, and she started the second grade. She turned 9 years old in December of 22. Her teacher in the second grade was Miss Rowe. Miss Rowe was pregnant, and she did a gender reveal for the kids that year. Nevaeh remembers a lot of details about the second grade because she was also in the second grade when she can remember that James Gregg, the man that she called daddy, put his fingers under her clothes, moved her panties to the side, and inserted his fingers into her vagina. Over the next 3 years, this man, taking advantage of his access to young Nevaeh, took several opportunities to sexually assault Nevaeh. And of course, the sexual abuse got worse and worse, including inserting his penis into Nevaeh. However, Nevaeh kept the secret because the defendant made sure that she wouldn't tell. But evil always has a way of showing itself. In early 2026, Nevaeh began acting out and interacting with things well above her age. She was making sexual comments, interacting with a sexual app on her phone, things like that. Dorothy, her mama, she became suspicious of the behavior, and she questioned Nevaeh about what was going on. Nevaeh didn't want to talk to Dorothy about it, but Dorothy has a best friend named Megan, and when Megan questioned Nevaeh about it, Nevaeh broke down and cried and told Megan what was going on. They then went back to Dorothy and told Dorothy what was going on. Law enforcement was contacted, and Nevaeh was taken to Cincinnati Children's Hospital, where she participated in what's called a forensic interview with Stephanie Helton. During the interview, Nevaeh disclosed the sexual abuse that had been going on for about the past 4 years at the hands of James Gragg. The interview was recorded, and it will be played for you today. Following the interview, a medical exam was completed. As part of the exam, tests were administered for sexually transmitted infections, or STIs. On April 8th, Cincinnati Children's Hospital notified Dorothy that 12-year-old Nevaeh had 2 STIs, trichomonas and chlamydia. Now, following the medical exam, a search warrant was conducted, and James Gragg was also tested for STIs. During the second testing, it was found that Gragg, the defendant, also had trichomonas. It was also discovered that Jessica Adams, an ex-girlfriend of James Gragg, had tested positive for chlamydia. After the testimony and evidence is presented, the court will go through the jury instructions with you. In those instructions, you will be told that rape includes the insertion of anything, however slight, into the vagina. Based on the definition of rape, this defendant inserting his fingers and then his penis into Nevaeh when she was 8, 9, 10, and 11 years old means that this man is guilty of rape. Thank you.
All right, on behalf of the defense.
Thank you. Good morning, ladies and gentlemen. Thank you for being here today. When you listen to the cases laid out by Mrs. Collins, it sounds horrible. I will agree with that. It's awful. But I would also remind you that the state has to prove each and every element of every offense beyond a reasonable doubt. Now, beyond a reasonable doubt is the highest level of doubt known in the legal profession. During voir dire, Mrs. Collins asked, don't hold her to some higher standard than that. That is the highest standard in the legal world.
Objection.
Overruled. Go ahead.
Thank you. So that is your task. You can't say, oh, we think it happened, or it sounds bad, or maybe. It's every element of every offense beyond a reasonable doubt. Now, Mrs. Collins also talked to you during voir dire about circumstantial evidence, and she is correct that circumstantial evidence is still evidence, and there are certain inferences that you can make. But I would also remind you that not everything, just because it is logical, is the correct inference. She used the snow inference. If you go to bed at night, there's no snow on the ground. You wake up in the morning, there's snow. The inference is it snowed overnight. I will remind you of Aaron Spelling, the TV producer back in the 70s, 80s, 90s, his daughter Tori Spelling. They lived in L.A. She wanted snow for Christmas. That was the Christmas present she asked for her dad, was snow. Well, they live in L.A. It's not going to snow, right? So he hired a company to come and bring snow in. So when she woke up on Christmas morning, there was snow all over their yard. The reason I tell you this is, in that case, the inference that there's snow on the ground, it must have snowed overnight, is not correct. So as odd as it may sound, sometimes just because something seems logical doesn't necessarily mean that it is correct. So I ask you to also keep that in mind as we go through the case, as you go through your deliberations. Do you guys, I don't know if you remember, many years ago, there was a famous case in California, the California daycare case, where all of these children that went to the same daycare were accusing the daycare owners of horrible abuse, horrible physical abuse, sexual abuse. And the daycare owners, they were indicted, they were tried, they were found guilty. And later it turns out that all of those children were lying.
Now, I'm going to object again.
I'll sustain that.
Opening, yeah.
It's not argument, so I'll sustain that.
Okay. The point is, don't believe everything that you hear. Not everybody, and I'm not going to accuse anybody of lying, but everybody has different takes on a situation. So always keep in mind that there are different takes or different explanations to things. keep your ears open for inconsistencies, and we will point these out again as the case goes along, but I ask you to keep those in mind. And Mrs. Collins mentioned the trichomosis and the chlamydia. But what she did not, well, she mentioned that James Gregg does not have chlamydia, and there will be medical doctors that will testify to the fact that he does not have chlamydia. In fact, there's no evidence he's ever had chlamydia. Now, I don't doubt that Nevaeh tested positive for chlamydia, and that's horrible. But keep in mind that she couldn't have gotten it from him, so there must be somebody else out there that may be interfering with this child. And if so, that person should be brought to justice. Thank you for your attention, and we will talk again after the evidence.
All right, thank you. First witness would state.
Nevaeh Penwell.
Were you sworn in down in the clerk's office? Yes. All right. If you could have a seat right over there in that chair. And when you speak up, please speak into that microphone and keep your voice up.
Okay.
All right, you may inquire.
Can you state your name for the record?
Nevaeh Penwell.
Can you talk super loud so that we can all hear you?
Nevaeh Penwell.
Okay. Can you spell your first name for the record?
Nevaeh.
Nevaeh, how old are you today?
I am 12.
And when's your birthday?
December 7th, 2013.
So you're going to turn 13 this coming December?
Yes.
Can we talk about school for a minute?
Yes.
Where are you going to school?
Greenfield Elementary.
So you're in McLean Tiger?
Yes.
What grade are you in this year?
6.
I'm going to show you what's previously been marked as State's Exhibit 5 for identification purposes. You recognize this?
Yes.
So does this truly and accurately tell what grade you were in, how old you were, and what year that was?
Yes.
And this is true and accurate? This
Yes,
is
ma'am.
correct? Nevaeh, can you tell us what your mom's name is?
Dorothy Marie.
And do you have brothers and sisters?
Yes.
Do you know James Gregg?
Yes.
And how do you know James?
He has been my father since I was 3 months old.
Do you call him Daddy?
Not no more.
But did you used to call him Daddy?
Yes.
Do you see James Gregg in the courtroom today?
Yes.
Can you point him out for the court?
Over there.
Please let the record reflect the witnesses identified the defendant.
Sword.
Have you ever been married to James Gregg?
No.
Now, after your mom and James split up, did you still go visit James at his house?
Yes.
Say it again.
Yes.
How often would you go over to his house?
Every weekend.
Can we talk for a minute about some events of March and April of 2026?
Yes.
Were you doing some bad things, acting out in March of 26?
Yes.
Were you doing things that you weren't supposed to be doing?
You object to leading?
Yes.
Yeah, that's correct. You're leading. I'll sustain that.
What were you doing that was bad?
I was downloading inappropriate apps that I was not supposed to.
Could you lean up closer to the mic, please, so we can all hear you? Thank you.
Do you know someone named Megan?
Yes.
Who is Megan?
She's my mom's best friend.
At some point, did Megan come to you about some of the stuff you were doing?
Yes.
And when that happened, did you tell Megan what was going on?
Yes.
What did you tell her?
I said that Daddy's been touching me.
Can you talk to me about maybe the first time that you remember him touching you?
Yes.
Tell me about that.
I was staying in his room watching TV.
And what happened?
He came back there and started it.
Keep your voice up, please.
You got to talk loud enough so I can hear you, okay?
I was staying in his room watching TV, and then he came into the room.
And what did he he do when he came
He
in there?
started messing with me.
And when you say he started messing with you, what did he do?
He put his hands down my pants.
And when he put his hands down down your pants, what did he do?
He put his fingers down there.
When you say down there, can you show me down there? Can you point to that part?
It was my vaginal hole.
Okay. Did he put his fingers in anything?
I'm going to object to leaving again.
All right.
I'll overrule that.
Or just put his hand down your pants?
He put it in there.
Okay. And when you say in there, where are you talking about?
My vaginal hole.
Okay. Do you remember being in the second grade?
Yes.
Who was your teacher in the second grade?
Miss Rowe.
Why do you remember that so well?
Because she got pregnant and she shared her pregnancy with us. Like she did a gender reveal too.
Did you like that?
Yes.
Was there anything, how old were you when you were in the second grade? If you looked at the chart, would that help you remember?
Yes.
May I approach?
You may.
I was 8 through 9 years old.
Okay. So, do you remember a time when you were in the second grade and Miss Rowe was your teacher?
Yes.
Do you remember a time that something like that happened?
Yes.
Can you tell us about that? It's okay. Can you tell us about that? Is it like what you just told us?
Yes.
Okay.
Mhm.
And did that happen at your house or at his house?
His house.
Okay. And do you remember what room that was in at his house?
Huh?
Do you remember what room it was in at his house?
It was in his bedroom.
Do you remember if you felt anything when he did that?
Yes.
What did you feel?
It hurt.
Is that the only time that he's ever touched you?
No.
Were there lots of times or not lots of times?
Lots of times.
Is there a time when he touched you when you were in the third grade?
Yes.
Do you remember the last time that something happened?
Yes.
Can you tell us about that?
It was Saturday, and I was like laying in his bedroom like normal, and he came in there and started touching me.
And when you say he started touching you, what do you mean he started touching you?
Put his hand down my pants.
And then what did he do?
He put his fingers in my vaginal hole.
And you said it was Saturday. Do you remember what month? Saturday of what month?
No.
Okay. Was it close to the last time that you went there?
Yes.
Okay. Was there a time that the defendant used something other than his fingers to touch you down there?
Yes.
And what did he use other than his fingers?
His boy part.
His boy part?
Yes.
And what did he do with his boy part?
He tried to put it in me.
And did it go in you a little bit?
Yes.
After that happened, did something happen with your body?
Yes.
What happened?
I got 2 infections.
Well, even before that, right after it happened, was there something that happened with your body?
Yes.
What was it?
I was on my period for 27 days.
Did you tell your mom about that?
Yes.
Okay. Now, why didn't you tell anyone that this was happening until Megan asked you?
Because I've said too many lies and I thought no one would believe me.
Where did you hear that from? Did someone tell you that?
No.
What kind of lies?
Like if my mom would ask me about a phone and I said I didn't know where it was, and then she would find it in my stuff, and then I would get in big trouble.
Do you have a puppy?
Yes.
Do you have a puppy at the defendant's house?
Yes.
And what was the puppy's name?
Sweet Potato.
Did the defendant tell you anything to do with that puppy?
He said that if I told anybody that I was not allowed to see her no more.
After you told Megan what was going on, do you remember going to the hospital and speaking with somebody there about what happened?
Yes.
And did you have an exam by a doctor?
Yes.
After the exam, did you have to take some medicine? Do
Yes.
you remember that?
Yes.
I want to go back and just talk about one thing for a second.
Okay.
How old were you when you started your period?
On my 11th birthday.
Okay. So, around December of 2024?
Mm-hmm.
Okay. And is that when you had your period for 27 days?
Yes.
And I just want to make sure that I don't have this confused. That was after you used his penis?
Yes.
No further questions.
Cross?
Hey, I'm Danielle.
Hi.
I just have a couple questions for you, okay? So you said you were bleeding for 27 days?
Yes.
Okay. Did you go to the doctor for that?
I'm pretty sure, yeah.
Okay. Do you remember what doctor you went to?
No. I'm pretty sure it was Dr. White.
Dr. White?
Yes.
Okay. Do you remember where that was?
No.
Okay. Do you remember what kind of building it was?
It was the hospital.
The hospital? Do you remember what city?
No.
No. Is it far away from your house or close to your house?
It was far away from my house.
Far away. And do you remember how many days you were bleeding before you went to the hospital?
Yes.
How many?
27 days.
So after 27 days you went to the hospital?
Yes.
Okay. And when did you tell your mom that you were bleeding, started to bleed?
I told her on the first day that I started of the 27 days.
Okay. And you mentioned that you don't call James Daddy anymore.
No.
Right? Okay. When did you stop calling him Daddy?
I stopped calling him Daddy when I told my mom's best friend Megan about it.
Okay. So that day you stopped calling him Daddy?
Yes.
So what made you tell Megan and your mom about it the day that you told them?
Because Megan, I feel safe with everything I tell her, so I told her.
Did you feel safe before about what you were telling them?
Yes.
Okay. So why didn't you tell them before?
Because I thought no one will believe me because of the lies I have told.
Have you ever told any lies like this before?
No.
But you didn't feel safe telling them earlier?
No.
Okay. Just a couple more questions, okay? Do you know, you said that James is not your biological dad, right?
No.
Do you know who that is?
My biological father is Carl Penwell.
Okay. And how often do you see him?
I do not get to see him.
Okay. When was the last time you saw him?
A couple months before my 11th birthday.
A couple months before your 11th birthday?
Yes.
Okay, so shortly before you started bleeding for 27
Yes.
days. Okay. No other questions?
Redirect.
Thank you. Today, when Miss Witt asked you about going to the doctor, you said you described the building as far away from you.
Yes.
Was that the building that you went to after you told what was happening?
Yes.
Okay. So that wasn't in December, but March when you told what was going on?
Yes.
Okay. No further questions.
All right. You may step down. Not to watch anything on YouTube about this case, right, until it's over, okay?
Yes, sir.
All right, go ahead and go out that way. Next witness.
Dorothy Mooney.
Did you get sworn in the clerk's office? All right, have a seat there, please. All right, you may inquire.
Please state your name for the record.
Dorothy Mooney,
And can you spell your last name for the record?
Mooney.
Have you watched any of the trial on YouTube this morning?
No.
Do you have any children?
Yes.
You have a child named Nevaeh Penwell?
Yes.
And what is Nevaeh's date of birth?
December 7th, 2013.
How old is Nevaeh today?
12.
I'm going to show you what's previously been marked as State's Exhibit 5 for identification purposes. Do you recognize this?
Yes.
And is this a chart that shows what grade, at what age, and at what year Nevaeh was in school?
Yes.
And is this a true and accurate chart showing that?
Yes.
Ms. Mooney, do you know James Gragg?
Yes.
How do you know James?
We're married.
And when you say you're married, are you living together?
No, we're separated.
And how long have you been separated?
For about 10 years.
Do you see James
Sorry to
Gragg?
hear that. How long?
About 10 years.
Do you see James Gragg in the courtroom today?
Yes.
Can you please point him out for the court?
He's in the white shirt.
Please let the record reflect the witnesses identify the defendant.
Sword.
Now, what sort of relationship did the defendant have with Nevaeh?
He was her father figure.
Did you allow Nevaeh to visit James at his home
Yes.
after the two of you separated?
Yes.
Where is his home?
6690 Golden Doubloon Lane.
Is that in Highland County?
Yes.
Let's talk about March of 2026. Was Nevaeh behaving in a way that gave you concern?
Yes.
What kind of things was she doing?
She was getting on inappropriate apps.
When you say inappropriate, what was wrong with them?
It's a AI app where she talks dirty.
And based on how she was acting, what did you do?
I had talks with her. My friend talked to her. She wouldn't talk to anybody. I just thought it's something that maybe she was going through.
Okay. When you say you had a friend talk to her, what friend was this?
Megan.
And after Megan spoke with Nevaeh, did Nevaeh tell you what was going on?
Yes.
And what did Nevaeh tell you?
I'm going to object to hearsay, Your Honor.
She's just testified to it.
The jury can hear what.
Well, wait a minute. She can answer the question for purposes of explaining the conversation, not for the truth of the matter asserted. The testimony of the Nevaeh would be that. So it is admissible for that purpose only. Go ahead. Overrule.
She told us that Daddy has been messing with her and touching her.
So based on what she told you, what did you do?
I went to the police department.
At some point, did you take Nevaeh to an interview at Cincinnati Children's Hospital?
Yes.
Now, following the interview, were you present when they did a medical evaluation?
Yes.
Was Nevaeh tested for STIs at the time?
Yes.
Did the hospital make contact with you after that appointment?
Yes, they did.
And what did they tell you?
They told
Objection,
me.
hearsay, Your Honor.
I'm going to sustain that.
After you spoke with the hospital, what steps did you take based on what they told you?
Put her on antibiotics.
I'm sorry?
Put her on antibiotics.
Did you do any follow-up testing?
Yes,
And when was that?
in July.
And do you recall a time when Nevaeh had her period for an extended period of time?
Yes.
When was this? Do you remember?
I think it was in May last year. I'm really not for sure.
Okay. Were you concerned about it?
Yes.
Did you actually speak with the defendant about it?
Yes.
And what did he tell you?
He said that it was probably something she was just going through. That it was no big deal.
Okay. Nothing further, Your Honor.
Cross.
Thank you, Your Honor. Dorothy, you said that you and James are married. When did you get married?
2003.
And you've been separated for about 10 years? And Nevaeh, according to your testimony, is 12?
Yes.
So you were still married to James when she was born?
Yes.
But James is not her biological
No,
father?
he is not.
Who is her father?
Carl Penwell.
And does Carl have a criminal history that you're aware of?
Yes.
Objection.
I think it's relevant, Your Honor.
I'm sorry.
It's relevant, Your Honor.
Okay. Brooks, please. Didn't actually get the last part of the question.
I asked if she was aware if Carl Penwell had any criminal history. She objected to this.
All right. Objection sustained.
Do you know when the last time that Nevaeh saw Carl was?
Last year.
You're not sure? I'm sorry. Can you
La-
speak up?
last year.
Last year? Okay. Now, when Nevaeh had this extended period, you said you thought it was in May of last year?
Yeah.
Do you know how long that period lasted?
It was about 3 weeks, probably.
You're going to speak up, Miss, too, so we can make sure we're getting recorded.
Did you seek any medical advice for that extended period?
No.
Did you have any concerns that she was bleeding for so long?
No. I just thought it was her. She just started, and I thought maybe just her cycle had to get regular.
When did Nevaeh turn 11?
Last year.
December of 2025?
24.
Of 24?
Yeah.
Okay. Now, even though you and James were separated, Nevaeh spent quite a bit of time at James's house. Is that true?
Yes.
And did you have any concerns?
No.
No further questions.
Redirect.
No further questions.
All right. You may step down. Don't discuss your testimony with anybody or watch anything on YouTube. Next witness.
Jessica Adams.
Were you sworn in the clerk's office? All right, have a seat over here, please. And keep your voice up and speak into that microphone when you're answering questions, please. Ma'am Clark.
Before we start, may we approach?
All right. All right, Ma'am Clark.
Can you please state your name for the record?
Jessica Adams?
And have you watched any of this trial today on YouTube?
No.
Do you know James Bragg?
Yes.
And how do you know James?
We were in a relationship around a little over 3 years ago.
Do you see James Bragg in the courtroom today?
Yes.
Can you point him out for the court? Please let the record reflect the witnesses identified the defendant.
It's ordered.
And how long were you and the defendant in a relationship?
A year and a half.
And how long ago did that end? I'm sorry.
Back in 2023, so a little over 3 years ago.
In February of 2026, did you go to the doctor?
Yes.
And what sort of treatment or what were you going to the doctor for?
Just a pap smear. And yeah, I ended up getting tested, got my results back February 20th, stating I have
Objection,
chlamydia.
Your Honor.
Overruled.
Now, based on your results, what did you do?
Was very much in shock, so got put on antibiotics.
You said you were in shock. Why is that?
I had no symptoms.
Now, prior to February of 2026, going back to the time that you and the defendant split, had you had any sort of STI screening or any appointments with a gynecologist in
No.
that period of time?
No, I have not.
No further questions.
Cross.
So, Jessica, you split with James about 3 years ago?
Yeah.
And did you have any other relationships between then and now?
Yes.
Were those intimate relationships?
Yes.
And no screening between then and now?
Besides the one in February, no.
No further questions.
Redirect.
How many intimate relationships?
Just one.
The person that you're currently with?
Yes.
No further questions.
All right, you may step down. Don't discuss your testimony with anyone until after the case is over. Next witness.
Your Honor, may we approach again?
You may.
You can go this way.
All right, ladies and gentlemen, the next witness is going to take an extended period of time, probably about an hour. So rather than starting and breaking in the middle of it, we're going to go ahead and take a lunch now. I know most of you were here by 8:30 this morning, not earlier. So we'll adjourn until 12:30 or so. During the break, remember all of the instructions I've given you about not talking with anybody, not trying to obtain any information about the case, not reading or listening to anything about it in any form in media, and not discuss the matter among yourselves, not to discuss it with anyone else or to talk with anybody that's been involved in the case to this point, or maybe in the future. All right, so when you come back, return back to the jury room at as close to... Yeah, I'm talking about that. And so when you come back by 12:30, then report to the jury room. When we do get to the point of deliberations, you will not be permitted to have cell phones, but you're going to leave them in your car. Instead of bringing them in, that's fine. Otherwise, when you do deliberate, we'll collect them and hold them for you until after deliberations are done. All right, we'll stand recess. Thank you.
Please rise.
All right, we're back on record. State versus James F. Gregg, 26 CR 49. The jury is in the jury room. And the counsel and the defendant are present. And just wanted to go on record now. On this witness, there's a video, and you had the opportunity to review that.
We watched it.
Okay, all right. And in my understanding, there's both a video and a report.
Yes.
And you received the reports?
We've looked that over, yes.
Okay. I mean, had you received it before? You said you weren't aware of the video of this victim, alleged victim, but you were of the other one that's not part of the case.
Correct.
All right. Now, for the record, I want to make, just to clear that up, is that reviewing the affidavit filed in the county court on April 16, it did refer to two children, an 8-year-old and a 12-year-old, and you gave the name. I didn't quite catch it.
Mariah.
But she is not part of this case, correct?
That's correct.
All right. And so, but apparently there were two Marison videos and two Marison reports.
That's correct.
And you received the reports on both children?
Right.
All right. Okay. So I will note in reviewing the compliance with discovery that was filed on May 21st that in item C4, the state disclosed Marison reports and Marison interviews and reports, which would be, that was plural, which would indicate the existence of more than one. And in this case, since we had two children, it would indicate a report on an interview on each. And then also on D2, Marison Center reports and two. And again, the council was aware of that. So regardless of whether the state neglected to provide it or if the defense counsel overlooked it, there's a provision on Rule 16K for the court to make orders that are appropriate, and by adjourning at lunch early and letting counsel review that, the court believes that that's sufficient under Rule 16K, Criminal 16K. Also note that the witnesses, being that the witness could testify to everything that's on the video anyway. Usually the objection from the old school, the Hapners and current era was, the best evidence is the recording. So even if the recording is not available, the witness nonetheless would be able under 803-4 to, Evidence Rule 803-4, I believe it is, to, 4, to testify to the entire conversation anyway. So with that, is there anything further, counsel?
I just do want to put on the record quickly that I have shortened the video from what it was originally. The beginning 10 minutes is just rapport building. The witness is going to testify to that. The last 10 minutes I took out because the victim talks about the defendant being in jail. I know that's not appropriate, so we cut that off.
All right. Do you have an objection to that?
No, that wasn't in what we watched. I did think when we were watching it while we were being watched, it started sort of abruptly, so I thought there must have been something before.
Yeah, okay. Well, obviously, you have no objection to those parts being redacted for purposes of the trial.
That's correct.
Okay. Particularly the part about any reference to jail. In fact, during the lunch hour, I've looked at my files on previous issues regarding this, and one of them was exactly that, where they were talking about it, and I had granted a motion in limine saying that part couldn't be admitted. So, okay. Anything else?
No, you're not.
All right, I'm going to step off. I get something else, and then we'll go ahead and bring in the jury.
Please rise.
seat, please. All right, we're back on record. State versus James F. Gregg, 26 CR 49. The jury is returned. We're ready for the next witness with the state. I'll remind everybody present in the courtroom to remember to turn off your cell phones. All right, your next witness.
Stephanie Helton.
Were you sworn in the clerk's office?
Yes.
All right, if you have a seat there, please. That's a microphone there, so please make sure you speak into the microphone.
Okay.
All right, you may inquire.
Please state your name for the record.
My name is Stephanie Helton.
And can you spell your first and last name for us?
Yes. STEPHANIEHELTON.
Have you watched any of the trial on YouTube today?
No, I have not.
Stephanie, are you currently employed?
Yes, I am.
Where are you employed?
I'm employed at the Mayerson Center, which is part of Cincinnati Children's Hospital.
And how long have you been employed there?
I've been employed there for almost 9 years, 4.5 years as a forensic interviewer.
And what are your job responsibilities at the Mayerson Center?
My main responsibility is to conduct forensic interviews. I also type up a report that basically summarizes what was discussed in the interview afterwards. I also talk to our medical team after the interview as well, so that the medical team can determine if there's any recommendations for medical treatment to be made to the patient. I also make mental health recommendations as well, assess the safety of the patient, and then testify in court.
And what is your educational background?
I have a bachelor's degree in psychology through Liberty University and a master's degree in social work through Indiana Wesleyan University.
Are you licensed with anything?
Yes, I am. I'm also a licensed independent social worker through the state of Ohio.
And do you do any sort of continuing education credits?
Yes, every 2 years, I have to get 32 continuing education credits within those 2 years to maintain my license.
And have you had a training in a particular field that you're specializing in now?
Yes, I've been trained in forensic interviewing.
Have you been declared an expert in child abuse forensic interviewing in any court in the state of Ohio?
Yes, in
Which courts?
Hamilton and Claremont.
At this time, I would ask the court to declare Ms. Helton an expert in child abuse forensic interviewing.
Objection.
No objection.
All right, you so declared and may continue.
Ms. Helton, what is a forensic interview?
A forensic interview, it is a recorded conversation between a forensic interviewer and a child who has disclosed or experienced or witnessed abuse. And so I gather information about the details surrounding the abusive incidents that have occurred.
And what is the purpose of performing an interview like this?
The purpose of the forensic interview is, first of all, I assess the child's safety. I also make sure that the child is connected with mental health services if they're not already. And then I also take the information that I gather from the interview and I talk to my medical team afterwards so that the doctor can come out and talk to the patient as well while they're there. They use the information that I give them to make any medical recommendations that may be needed, such as an exam or testing for sexually transmitted infections.
Now, during the interview, are there specific techniques that you employ?
Yes. So in a forensic interview, it is audio and video recorded. It's just the child and the forensic interviewer in the room. If there's any investigators present, they watch from a different room. And then the child also there's some fidget items in the room too, just so they can keep their hands busy while they're talking if they need them. And then the interview itself is conducted in a non-leading way. A lot of open-ended questions are asked so that the child can use their own free recall and words to talk about their experiences.
And what is the underlying purpose of not using leading questions?
So that the child can use their own words. They're not guided, told specifically what to say. They're using their own free recall about what's happened.
On March 18th of 2026, were you asked to perform an interview of Nevaeh Faith Penwell?
Yes.
And did you prepare a report following that interview?
Yes, I did.
My first witness?
May.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
Yes, I do recognize this.
And what is that?
This is the report that I typed up after my forensic interview with Nevaeh.
And did you complete that report during the ordinary course of your work or your business following the interview with Nevaeh?
Yes, I did.
And based on your review of the report, what is Nevaeh's date of birth?
Nevaeh's date of birth is December 17th of 2013.
And on March 18th of 2026, when Nevaeh came to the Mayerson Clinic, what was the process of the interview? How did it start out?
She was brought to the appointment by her mom, so I introduced myself to them. I let them know that Nevaeh and I would be going back into a different room to talk and that we were being recorded. Her caseworker was also present, so I let them know that the caseworker would be back there as well, but watching from a different room than us, that it would just be her and I in the room talking. I let her know that there was a medical doctor present, so anything that we talked about today, we could talk with the doctor about as well after the interview. And also let them know about mental health recommendations if they're needed. Afterwards, we would talk about mental health services.
And did you record the interview?
Yes.
I'm going to hand you what's previously been marked as State's Exhibit 2 for identification purposes. Do you recognize this?
Yes, I do.
Is that a true and accurate copy of the interview of Nevaeh?
Yes.
Now, for about the first 10 minutes of the interview, you're just talking to Nevaeh about random things. What are we calling that?
That is called rapport building. I conduct that I do that in all of my interviews. It's basically just taking about the first 10 minutes just to get to know the child a little bit. The purpose of that is just to make them feel a little bit more comfortable talking about, when we actually get into talking about why they're there. And that helps me too. It's part of assessing safety too, because I a lot of times ask, who you live with and things like that as well.
Do you kind of lay some ground rules or guidelines for what's about to happen during that time?
I do. So during rapport building, when we first get in the room, I introduce myself and I let them know what my role is, to talk to them, make sure they're safe and make sure their body's healthy. And then I go over 5 rules with them before we start. So the first rule is, if I ask you a question and you don't know the answer, it's okay to tell me that you don't know. I don't want you to guess. If I ask you a question and you do know the answer, tell me everything you know. I also let them know that if I say something back to them and it's wrong, to let me know, because it's important that I hear exactly what they say. And then I also let them know that if I ask them a question and they don't understand what I'm asking, to tell me so that I can ask it in a different way. And then the very last rule is that I ask that they will promise to tell me the truth, and that it's really important that we only talk about the truth.
At this time, the state would move to admit State's Exhibit 2 and publish the same for the jury.
For the record, it's a partial part of the recording as we discussed
Yes,
earlier.
that's correct.
Any objection?
No objections.
All right. May play.
then the people died. Oh, I'm sorry to hear that. I hope everything goes well this time. Well, thank you for telling me some things about you and helping me get to know you a little bit. You're welcome. So tell me what you're here to talk to me about today.
I can talk to you about what has happened.
Okay. Tell me about that.
So this man is just good. He has lived me since I was 8 years old. He hasn't talked to me regularly. I didn't know him. He doesn't listen to me. So
Has this happened one time or more than one time? Okay. So there, I mean, you can think back to the very last time that he touched you appropriately, okay? And start from the beginning and walk me through everything that happened that last time.
it was like the last day of the second month. It was like a Saturday, I believe.
Okay.
And I was flying in his room. I always did like watching his TV. He comes back and he starts taking my kind of his mom. He keeps looking at his face.
So this last time that you could tell me about, describe to me what he did when he was touching you.
He did and he had to go and stuff. And I was so afraid to go home. I was
Okay. Describe to me what he did with his hands when he put down your hands. So his fingers inside of you? Okay. What part of your body did he stick his fingers inside?
So I am 12 and I did get my period on my 11th birthday.
Okay.
And he said he can just go my birth until I know.
Okay. Did he say something to you when he was doing that there last time? Okay. Tell me more about that part when he said not to tell me.
He told me that I found the camera, but he didn't believe me.
Did he say what would happen if you told? What else happened that very last time when he touched you?
He has anger issues with his head.
Okay. What happened when you got mad that last time?
She goes from body's from going to his head.
And what did you do when he stormed out and went to the room?
I stayed in his room and looked up the room and started watching my favorite, really not a movie, but a season episode that's called The Show. I watched it all the time.
And so then what happened?
And then it was time for dinner, so I went over the living room and I sat away from it and I ate it.
Okay. And what happened after you did?
Then after I ate dinner, I went to his room for a little bit, and him and his fiance and his Steve went to bed. I went in the living room where I was sleeping, like I usually do. I lay down on the couch and watched TV for a little bit, and then I fell asleep.
Gotcha. Okay. What's his fiance's name?
Miss Jefferson.
Where was she this last time that you
She was in the kitchen.
Okay. Was someone else there other than Misty, James, and you?
There was Mariah, she was there.
Okay, gotcha. Where did this happen?
And it was kind of in Hillsville, it was in one before the lake.
Okay.
I don't know the street name, but he has a trailer and he has a red truck, a van, and like a kind of like a skin color car, and
there's like some food by it, and if you go back, there's going to be a lot of dogs out there. So, and I have a dog myself out there, which I can get it. This is the page. She went to James's house and got her two dogs. She couldn't get my dog because she was in a hurry. She didn't want to sit there after what I said.
Gotcha.
My dog was
where were James's clothes when he touched you inappropriately the last time?
they were on.
Okay. Were they all the way on or a little bit on or something else?
They were on.
Okay. And then tell me what you were wearing when you started
I
saying you were wearing.
was sweatpants and a hoodie.
Okay. What did the sweatpants look like that you were wearing?
They were in my stitch ones. I had stitched them here.
Gotcha. Gotcha. Okay. And then did you have something else on underneath your sweatpants? Underwear? Okay. So when James stuck his hand inside of your pants, how were your underwear?
They were like regular, something like that. They're regular.
Okay.
And like I said, I pushed them away. What it was, I had to push them again and then he left them.
Okay. Where were your underwear when he stuck his hand inside your pants?
They were on.
They were on. Okay. Help me to understand how he stuck his fingers inside of you with your underwear.
He was saying some of him and then
Gotcha. What else happened that last time?
I accidentally everything.
Did he do something else to your body that last time? Did you feel unsafe or uncomfortable? Did he do something in his body that last time? Did you feel unsafe or uncomfortable? And you said that happened the last day of the second month. So are you talking about February?
Yeah.
The last day of February?
It was Saturday.
Okay.
It was the day I started I got my period, and like I said, I got my first period when I was 11.
Okay. So what year did this happen? This very last time? 2006. And so that was the first day of your very first period?
Not a day first. Honestly, I can't remember.
Okay.
I started in my first period on which was Saturday, basically 7.
Okay. So I want to make sure I understand. Did you say this last time that it happened, it was the first day of your period? No. Okay. That's why I always ask. I must have misunderstood that. So just like you just said, tell me all about the very first time that he touched you inappropriately.
Not gonna lie, I can't remember.
Okay.
I was going on. I've been moving, going to school, and stuff like that.
Okay.
And a lot of stuff like that on my schoolwork. And when I get home, with my stuff, with my friends, outside, so
Okay. Tell me all about the time that you remember the most.
but I remember the most when we first started dating. I was like in his bedroom. He was with
Okay. What made him stop that time? And what happened when he stopped? And then what happened? And what happened when you were in the middle of the room? Then what happened? Okay.
And then we came back, I got text from this guy, and then something came and I away from James, and I ate dinner, and then I took a shower, and then I went to bed, and I got my phone, and lay down, watched the news, and fell asleep.
And where did this happen at? This time that you said?
And his outside the piano now, he's in
Okay. So it's the same trailer that you just told me about? Okay. Tell me who all was there when this happened.
my sister Morgan, she was in her room, and there's like an house, was in the kitchen cooking, and I was in the room.
Okay. So when he touched you inappropriately this time, you were in the living room when that happened?
I was in the kitchen, I was in the kitchen.
You were in his bedroom when it happened. Okay. So you were in his bedroom, Sister Morgan was in her room, and then you said Jessica was in the kitchen cooking. Okay. Was someone else there?
No, she was in
Gotcha. How old were you?
about 7 or 8.
And describe to me more what he did that time when he put his hands in your pants and in your hair. Okay. Did he say something to you? Okay. Did you say something to him? Okay. What happened when you told him to say? What did he do when he got on his phone? Describe to me what he did to your body that time.
I was alone in bed on my stomach.
Okay. And what happened when he got on top of you?
He rolled me over, take off me, and started slapping
And what did he do with his hands when he stepped on your face?
me.
Okay. The same part of your body that you already told me about, or a different part of your body? The same part. Help me understand what he was doing when he was on top of you.
Was What about his clothes? Where were their clothes? Okay. And it's okay if you don't remember this, but you remember what you were wearing. What else do you remember about that time that you just told me about? Was there ever a time when something different happened, other than what you've been telling me and him putting his hand in your pants and not shutting your mouth? Okay. So start from the beginning and walk me through everything that happened that time that you remember.
So that's how I was in bed and I was before. And then before I had gone to stop there's no way he tried to get his body pushed it away.
Okay. Describe to me what he did when he tried to stick his body part inside of you.
With my pants down, I put on my belt, get my pants down, hold my belt. And that's when I feel kind of soft.
Where were you wearing something underneath your pants? Okay. Where were your underwear that you pulled your pants down? They were on? Okay. Where were his clothes? Okay. Help me to understand how you knew he was trying to stick his body part inside of you. Okay, tell me more about that part. Okay. And what happened with that topic? Remember I told you we were doctor here today. And so this is why I'm asking this question, because it's important that I understand. How far did his body part go before he stopped? Okay. Was his body part, did it touch you at all? No. Okay. What part of his body are you talking about? Okay. What do you call that?
I call it the voice private part.
The voice private part? Okay.
Because someone was sick. So that, like, for the people that go car at my house.
And when you know, you can say whatever words that you need to hear. Okay? You don't get any trouble with me. It's just important that I understand what you're talking about. Okay? But I understand what you're saying when you say voice private part. And where was he trying to put that? Okay. Tell me everything that you saw when he took his pants down. Okay. Tell me what you heard. Okay. Tell me about that. What did your body feel when that was happening?
I felt scared. I didn't know what to do. So they did it, and I didn't really want to. They did something at first, and then they pushed me away.
help me understand what was happening before you pushed him away. Describe to me what was happening when he was trying to sit. Like, help me understand what you mean when you say try. He was trying to do that. Okay. Tell me more about him having the pen down. What part of the bed were your arms pinned down to? You have your arms pinned down at the top of the bed with his left hand. What was he doing with his other hand? What else happened during the outbreak? And so what made you stop? Okay. And what did he do when you pushed him away? Did he stop? Okay. What happened when you left the room? And then what happened? What was done? Oh, the dinner was done. And then what happened? How old were you when that happened? Okay. You told me that you started your period when you were 11. Did it happen before you started your period or after you started your period or something? Before you started. And did it happen in that same trailer or somewhere else?
In the same trailer.
Who was all there at that time? Okay. Do you remember anybody that was there at that time? No. What else do you remember that was going on around that time when that happened? Okay. Okay. How come you spending a lot of time in this room that time? Do you remember what grade you were in when that happened? Or anything else that was going on around that time? If you were in school or not in school, or anything else that you remember about that time?
I believe I was in third grade.
Okay. How come you think you were in third grade? Gotcha. Okay. What else do you remember about that time that you think I should know? Okay. Has you tried to put his boy private in your body one time or more than one time? Okay. So that time you told me that he tried to do it, that he did want that. And that his boyfriend did not touch your body. Was there ever a time that it was different? What happened was different? Okay. I'm going to ask you this more specifically because, again, I want to make sure that your body's healthy. And what happens after we finish talking is I go to talk to the doctor to let her know what you shared with me so that we can make sure that your body's healthy. Okay? Mm-hmm. Was there ever a time when his boyfriend touched your body in some way? Okay. Was there ever a time when something different happened? Mm-hmm. Okay. Did this ever happen to someone different other than his room? Mm-hmm. When he touched you appropriately? Okay. Tell me all about a different time you remember when he tried to put his boyfriend up in your body.
I remember this.
Okay. Describe to me what he did that time.
He like got on top of me again, but kept his pants on instead of my pants on.
So describe to me what he was doing when he got on top of you that time. What happened when you pushed him away? Okay, what happened when you got angry? Gotcha. Okay. How do you know that he was trying to put his boyfriend in that time?
When I was close to my body, I heard his bell before.
Okay. What else did you hear? What else? Tell me what you saw long before you closed your eyes. How far down did his veins get that time? Okay. Did he have something else on underneath his veins?
His box was really
You do. Okay. Where were your clothes that time?
they were all the way on.
They were all the way on. Okay. Is that what you said? All the way on? Okay. Describe to me how your body was on the bed that time.
I was laying on the bed.
Okay. And you told me about the other time that he pinned you down. Did something like that happen this time? No? Okay. What was he doing with his hands this time that you just told me about? What else happened? How old were you when that happened? I mean, you were 8 or 7 or something? And did that same question before that happened, that same trailer, a different trailer? Or I'm sorry, a different place? Same trailer? What else happened last time that you think I should know? Did he ever do something else to your body other than what you've already been talking about? Okay. Did he ever make you do something to his body? So help me understand how you found out about what happened. What's his name? Jay and Megan Jordan. Okay. So you said you were talking to her.
Yeah, and she talking about my behavior, and she said, often, Miss Dawn is out, and then I finally James.
What happened when you showed her love?
I told her, and then I told her that person out fine, and then so did my mom and her, and mom was doing some stuff, but and then some stuff.
And so then what happened with her?
After that, I left with my mom, like, she's a page, she was very kind, and we have together. And a little before, after I told Megan and my mom about what she did, that was her sister and I had some stuff. And after that, my mom had to leave me to the police station, and then go to the police station.
That was hard for you to tell someone about it. Have you ever told someone before? How come you felt like you couldn't tell someone before? What do you mean?
So when my mom asked me if I wasn't from Houston, and then she watched my family follow up with me.
Okay. And so, help me understand what you mean as to why you felt like you couldn't tell mom before. Because of what lies you told them. Okay. When do you feel like you were ready to tell Joe about this?
Megan, she said that everybody there in the night was for James. That everybody there for me came. And I got to me, I finally told her.
How do you feel since you told me?
When she told me that, I actually felt, I actually happy.
Do you feel safe and supported by mom since you told? Have you ever seen James do something to someone else's body? Has someone ever seen James do something to your body? Has someone else ever done something to your body that's made you feel unsafe or uncomfortable? Has someone ever made you do something to their body that's made you feel unsafe or uncomfortable? Something else that I talk to kids about is just making sure they're safe on phones, tablets, and computers, things like that. And I first want to know, what is Pop-Quiz?
Okay, that's just so you know get
Okay. Has something ever happened when you've been on your phone that's made you feel unsafe or uncomfortable? Has someone ever sent you pictures or videos that made you feel unsafe or uncomfortable? No. Has someone ever asked you to send pictures or videos that made you feel unsafe or uncomfortable? No. Has someone ever shown you pictures or videos that made you feel unsafe or uncomfortable? No. Has someone ever taken pictures or videos of your body that's made you feel unsafe or uncomfortable? No. Something like that ever happened, you used to see a grown-up in the hotel. So Nevaeh, what I'm going to do is I'm just going to step out of the room and look over my notes and see if I have any other questions for you before we finish up, okay? So give me just a few minutes and I'll be back.
Ms. Halton, when you returned to the room, did anything about the interview, anything change?
No.
Now, after your interview with Nevaeh, did you determine that she didn't need to seek further medical treatment?
Yes, I spoke to the doctor about it afterwards.
I'm going to hand you as previously remarked as State's Exhibit 3 for identification purposes. And do you recognize that?
Yes, this is Nevaeh's medical record from Cincinnati Children's.
And the front page here, do you know what that is?
I do not.
Can you just look at it?
Mm-hmm. So it says that I hereby certify that the attached data are true copies of the records requested.
So it's a certification of true and accurate records?
Yes, that's correct, from Cincinnati Children's.
Okay, and if you look at the page that I have marked, what page of the record is that?
Page 51.
And according to that, were there STI testings that were done?
I'm going to object that this is hearsay.
Rule.
Yes, there was.
And what were the results of those? Oh, let me stop you first. What's an STI?
That's a sexually transmitted infection.
Okay, and what were the results of that?
She tested positive for trichomonas and chlamydia.
Okay. Now, thank you. Can you tell us what a pediatric TSCC is?
Yes. So that is a trauma symptom checklist for children. So when families come into the Mayerson Center, they're handed it's a screening measure is what it is. And so it's something that either the child, if the child's over 11, the child fills out the paper, or if the child's between 5 and 10, the caregiver fills it out. What it is it asks different questions, and it essentially helps to determine how much traumatic experiences have impacted a child's behavioral health and their mental health. So I take that paper from the child or from the caregiver, whoever completes it, and then I score it. And then that shows me whether it can be either negative, positive, or concerning results. That helps to guide me in my mental health recommendations for the child.
And did Nevaeh complete a TSCC?
Yes, she did.
And when you scored it, what was her score?
The highest you can get is 44. She scored a 24, which is considered concerning.
And concerning, based on that, what were your recommendations as far as mental health treatment?
I recommended that she be connected to mental health services. Her mom let me know that she was already connected to someone.
Based on your experience in conducting forensic interviews, and your training in the field, is it common for a child to wait to disclose sexual assault?
Yes.
Is it more common for a child to wait to disclose if the abuser is a parent?
Yes.
Based on your experience in forensic interviewing and your training, what are some reasons that children wait to disclose?
One of the reasons is feeling shame or feeling guilty, like somehow they allowed what's happened to happen. They may feel embarrassed, fear. They may be afraid of what's going to happen when they tell, if they're going to get in trouble. Sometimes, if it is a parent and the parent's the sole financial provider, they may be afraid of what's going to happen when they tell, if they have to split from that person. And they can also be fearful of the person who's done this to them, what they're going to do once they find out that they've told.
Based on your experience, is it, and your training, is it common for a child to disclose more details as they become more comfortable talking about things?
Yes, in my experience, kids don't often disclose everything all at one time right away. In my experience, it's more common for kids to disclose at a later time and little by little.
So the fact that Nevaeh said to you he didn't put his boy part in, if she now is saying yes he did, would that surprise you based on your experience?
No, it would not.
I have no further questions.
Ross?
Just to clarify, did Nevaeh say to you that there was consequences if she told anybody about what had happened?
No.
So there was no consequences?
I don't know that there was no consequences, but she was told to not tell.
Okay. But she stated that there was no consequences.
She didn't state that there wasn't consequences. She just said that he didn't say what would happen if she told.
Okay. And then, just because some of it was muffled for me to hear from here, did she say that she did not remember the very first time it happened?
Correct.
Okay. And did she say why she didn't remember? Did she explain that?
I don't recall that she said specifically why she didn't remember.
Okay. And when she mentioned Jay and Megan Jordan, who did she say that was?
That is her ex-boyfriend's family. Those are the people who she disclosed to.
Okay. And did she say whether that was at their house?
I don't recall, to be honest.
Okay. All right. Some more questions?
No further questions, Your Honor?
All right. Any redirect?
No, I said no.
Oh, I'm sorry. Okay. All right. Let me step down. Thank you.
Okay, thank you.
Yes. Thank you.
Next witness.
Dr. Terpstra?
Come on, right here. Were you sworn in the clerk's room office? All right. If you have a cell phone, turn it off. Just have a seat there, please.
Can you please state your name for the record?
John Terpstra.
And can you spell your last name for us?
Terpstra.
Have you watched any of this trial on YouTube today?
I have not.
And what is your occupation?
I'm a physician.
And where do you currently work?
I work at 3 locations: Highland District Hospital, then Wilson Health up in Sydney, and Wayne Hospital over at Greenville.
What do you do at Highland District specifically?
Emergency room department physician.
Okay. And were you employed or were you working at Highland District on April 23rd of 26?
I was.
On that date, do you recall a patient named James Gragg?
I do.
I'm going to hand you what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
Yes.
And is that a certified copy of the medical records for James Gragg?
It is.
And can you look at that and tell me what James' date of birth is?
I'm going to object to this here, so.
Overruled in certified records.
Date of the visit, date of birth 6/18/82.
And have you had the opportunity to review those records prior to today?
Yes.
And are those records records the hospital retains in the ordinary course of business?
Yes.
I'm going to refer you to pages 13 and 14, which are marked with a sticky note for you.
All right.
Can you tell, from reviewing those records and from your own memory of the day, what testing was done to James Gragg?
There were chlamydia, gonorrhea, and trichomonas tests. Trichomonas tests were done.
And what were the results of those tests?
So the trichomonas test was positive, and the chlamydia and gonorrhea tests were negative.
Okay. Can you tell us what trichomonas is?
Trichomonas is a protozoal infection. It is specifically sexually transmitted. It's a common sexually transmitted illness.
But is it a sexually transmitted illness or infection that you're going to pick up in a public bathroom?
Absolutely not. No.
Would you find it uncommon for a 12-year-old to have this?
Absolutely. Absolutely.
Are you familiar with chlamydia?
Mm-hmm.
And what is it?
It's a bacterial infection, also sexually transmitted, fairly common. How much detail do you need to go?
That'll do. What is the treatment for trichomonas?
Typically flagyl. There's a couple other medications which are rarely prescribed, but typically metronidazole or flagyl medication.
And what is the treatment for chlamydia?
There's a few different antibiotics, doxycycline, zithromax, or azithromycin are pretty common antibiotics that are used. There's a couple others as well.
Azithromycin, like a Z-Pack?
Yep.
Treats chlamydia.
Yes.
Can you tell us what is the difference between an STI and an STD?
They're pretty much the same thing.
They're the same thing?
Yeah, yeah. Yep.
If a person took the azithromycin or a Z-Pack, that's used to treat chlamydia. Is that what you said?
Mm-hmm.
Will that also treat trichomonas?
No.
Are there, well, I think that's it. No further questions.
Okay.
Ross?
Thank you, Your Honor. Dr. Terpstra, Mrs. Collins asked you if trichomonas could be caught in the bathroom. I'll ask you the same question about chlamydia.
No.
Does that take skin-to-skin contact?
Yes.
Not something you catch off a toilet seat?
No.
Can it be caught through the clothing?
I can't give you an exact answer on that.
Okay. Would it seem to be unlikely?
It would be unlikely. Yeah.
I have no further questions.
Redirect.
None, Your Honor.
All right. Thank you. Excuse me.
Thank you.
Your next witness?
Yes, you can. Thank you. Lieutenant Ansdorf.
Have you been sworn in?
I have not, Your Honor.
Would you raise your right hand, please? Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
See there, please.
Can you please state your name for the record?
So I'm Lieutenant Vincent Antinor of the Highland County Sheriff's Office.
And can you spell your first and last name for us?
Vincent, Antinor, Antinore.
And you said you're with the Highland County Sheriff's Office?
Correct.
How long have you been employed there?
Just about 15 years now.
And what are your job duties there now?
So currently I supervise 3 different divisions, including the Detectives or Investigation Division. That's where I work. The primary area of my day I spend working as an investigator or detective handling high-level felony cases.
Have you had specialized training in specific sort of cases, child abuse cases, sexual assault cases, things like that?
Correct. So I mainly handle high-level felonies. In Highland County, what we mainly get is child sexual assaults as far as a high-level felony. So I've focused my training and education and career based on child sexual assaults and child abuse cases. That's where I've received most of my specialized training.
And over the course of your law enforcement career, can you tell us about how many sexual assault cases have you investigated?
I couldn't. The truth is, it's just too many cases to remember, nor would I really want to. These cases are just the most sensitive cases. So I've primarily handled all of the sexual assault or rape cases that have come into the Highland County Sheriff's Office since sometime in 2018 until now.
And were you employed in this capacity in March of 2026?
I was, yes.
And did you become familiar with the complaint regarding Nevaeh Penwell and James Gragg?
I did, yes.
And what steps did you take once you became familiar with the complaint?
So when I was first notified of the complaint, just like any time a juvenile would disclose sexual abuse, I worked with her family. In this case, it was Dorothy Mooney, that's her mother, and Highland County Children's Services to ensure that Nevaeh was seen at the Merison Center up at Cincinnati Children's Hospital.
And did you, once she was seen at the hospital, at Cincinnati Children's Hospital, did you receive the results of the visit?
Correct. So I believe she was seen on March 18th. The following day, March 19th, is when I received a portion of the results. Obviously, all of the medical testing and things all those results weren't available immediately. But the very next day, I received a portion of her disclosures where she disclosed that she was sexually assaulted and raped by James.
And over what period of time did those assaults take place?
So Nevaeh disclosed that they began sometime near the 2nd grade, and then they continued up until pretty recently when she reached out and asked for our help.
And did she say where these assaults took place?
She did.
I'm going to object to his repeating what Nevaeh said. She has testified, and so anything that he's repeating that Nevaeh said is hearsay.
Well, she's testified, but it is hearsay, so I'm going to sustain objection and move on.
Based on the location that Nevaeh gave, were you able to determine the address of the property?
Correct. James's address was found to be 6690 Golden D Lane. That's in Paint Township of Highland County, right in the Rocky Fork Lake region.
At some point, did you receive a copy of the medical records from Cincinnati Children's Hospital?
I did, yes.
I'm going to hand you what's previously been marked as State's Exhibit 1 for identification purposes. Do you recognize that?
I do. This is a copy of the Merison report from her March 18th visit.
And I'm next going to hand you what's previously been marked as State's Exhibit 3 for identification purposes. Do you recognize that?
I do. This is a certified copy of the medical testing results related to her March 18th visit.
And when you received those records, specifically the medical portion of the records, did you review those?
I did, yes.
And did you take note of anything in particular?
I did. I found that contained inside the medical records, Nevaeh had tested positive for chlamydia and trichognomoniasis, if I pronounce that correctly.
Based on the medical records, what did you do?
So, contained inside the medical records, obviously she tested positive for 2 STIs that were you could only contract them through sexual intercourse. She disclosed that James is the person that had sexual intercourse with her, so we executed
Once again, I'm going to object to what she has said.
Sustained.
Okay, based on what she said, what did you do?
Executed a search warrant to test James Gregg for these sexually transmitted infections.
And how many times did you do search warrants?
So we had to do 2 different search warrants and repeat this testing. There were some problems with the first round of testing that we conducted, so we conducted a second round of testing on James.
I'm going to hand you what's previously been marked as State's Exhibit 4 for identification purposes. Do you recognize that?
I do.
And what is that?
This is a certified copy of the ER visit and testing results from the second round of testing that we did on James.
And do you see, and what were the results of those tests?
During this round of testing, James did test positive for the trichognomoniasis, or trick as it's commonly referred to as, but not the chlamydia.
And do you see the James Gregg that you took to be tested for STDs or STIs in the courtroom today?
I do.
And you went not to the court?
He's seated at the defense table between Miss Hatner and Miss Witt in a white shirt.
Please let the record reflect the witnesses identified the defendant.
So
Now, after receiving the defendant's medical records with the test, did you attempt to determine if he had been treated with any antibiotic?
I did. So I learned that common antibiotics would treat the chlamydia, which would be a reason he didn't test positive for it.
So to that, he's drawing a medical conclusion, and he has no medical background.
approached? Tell me how this is.
Did you attempt to pull prior antibiotics from an ORS report from the Board of Pharmacy?
I'm going to object to that. But there's no indication as to what the ORS report is. There's a foundation for that.
Okay, then that's sustained.
What's an ORS report?
So an ORS report is the Ohio tract if you are prescribed controlled substances. So every time a doctor would prescribe you something that's a controlled substance, the state of Ohio tracks that through a system called ORS. Law enforcement as well as medical professionals have access to that where the general public does not. So I have an ORS account where I can see or run an ORS report on a person for a specific criminal investigation. I did that in this case for Mr. Gregg to attempt to see if he had been prescribed any type of antibiotic. Through that process, I learned that ORS
I would
does...
object that this is then hearsay.
And I'll overrule that.
Through that process, I learned that antibiotics are not tracked through the state of Ohio or through ORS.
What is the defendant's date of birth?
June 18th of 1982.
So during the time of the sexual assaults, was the defendant over the age of 16?
He absolutely was. He was actually somewhere around the age of 39 the first time that Nevaeh disclosed he sexually assaulted her.
Based on your training and experience, is it uncommon for victims to wait to disclose sexual assault?
It's actually the most common way that I get reports is delayed disclosure reports. It's very rare that we get a report as it happened or immediately after it happens.
And based on your experience, do disclosures start small and then grow as a child becomes more comfortable?
Yes, it's not just more comfortable, it's more trusting in the person that they're disclosing to or the process of the disclosure, the team that's supporting and surrounding them.
In the sexual assault cases that you have investigated, how many of those cases involved the recovery of DNA from the victim?
It's it's possible, but it's very, very seldom. When these children, like in this case, disclose these sexual assaults, it's, again, a delayed report. And it's not something where we can go after time has passed. Physical evidence like DNA, it degrades, it doesn't exist anymore. It's not very common at all that we would be able to recover any physical evidence or DNA.
I have no further questions.
Cross.
Thank you, Your Honor. Then you don't have any particular medical training, do you?
I am trained through the CDC for concussion protocol and basic first aid for coaching.
Okay. And that has nothing to do with this case, does it?
No, it does not.
And you said, I think you testified that you don't know how many of these cases you've investigated?
Correct. Just too many to count or possibly remember.
Nothing further, Your Honor.
Redirect.
No, nothing further, Your Honor.
No, you're stepping down. All right. Next witness.
No further witnesses.
All right. Ladies and gentlemen, at this time I'm going to ask you to retire into the jury room. We'll have to deal with a few legal matters, and we'll probably be about 15 minutes. If you want to leave the building or go outside the courtroom, you may, but don't come back in until we have concluded the proceedings here. We have to have some proceedings outside the presence of the jury. So you can either go to the jury room or you may leave the room during the proceedings. If you go to the jury room, please last one in, close the door. So, okay. That door's closed. All right, we're back on the record. State has no further witnesses, so I assume you're moving exhibits to be admitted.
Yes. We would move to admit exhibits 1 through 5.
Do you have those? Any objection?
We'll object to the Highland District Hospital records as not being, I realize that they are certified records. However, there was no testimony about Dr. Terpstra's qualifications to even say that they were certified.
Well, he's a physician at the hospital, so I'll accept that. So it'd be overruled. Any other objections?
No.
All right. Thank you. What?
The fifth one is right here.
And what is it?
It's her age.
Oh, the chart. Okay, gotcha. Okay. All right. So state rest?
Yes.
All right. On behalf of the defense, any motions?
We would ask for Rule 27 motion that the state, I'm sorry, 29, I always say Rule 29 motion that the state has failed to prove a prima facie case.
Response.
Your Honor, the evidence is such at this point that reasonable minds come to differing conclusions, and as such, it is appropriate for the jury to decide this case.
Well, the court's view, it would be a matter of credibility and weight of the evidence, which is the duty of the fact finder, which in this case is the jury, and therefore the court will deny the motion. All right. Are you going to present any evidence?
I do. I have one witness.
All right. And that witness present?
He is on his way.
On the way? All right. Okay, well, let's take about 10 more minutes then, and as soon as your witness is here, we'll let the bailiff know. We'll go ahead and get back. Before we go off the record, just in terms of the jury instructions, are there any objections to any of the instructions or any requests for any additional instructions that are not in those? And I did make the change as far as the right of the defendant not to testify. And I don't remember, I believe it's in here, but I'll have to check. But I also usually put in a provision that when a defendant's in custody, that the fact they're in custody, if the jury has noticed it, which they usually do since they're not stupid, that they can't consider it for any purpose. You have no objection to that?
No.
Okay. All right. And then I did make the changes on the 2 verdict forms that you pointed out this morning had the wrong case number. Forgot to delete one of the numbers in the case number on counts 2 and 3. Anything else regarding jury instructions then?
No, Your Honor.
Okay. All right. Well, we'll take about 10 minutes, like I said. When your witness is here, let me know.
Please rise.
All right, we're back on record on case number 26 CR 49, State of Ohio versus James Franklin Gregg. The state rested, and we're now on the defense case. Remind everybody in the courtroom, turn off your cell phones if you haven't. Ms. Hapner, you have a witness?
Yes, Your Honor. I'll call Dr. Jeff Beery. My understanding is that there's a stipulation as to his medical qualifications.
Okay.
Yes, Your Honor.
All right. Dr. Beery. Did you get sworn in the clerk's office?
Yes.
All right. Just have a seat over there. May inquire?
Thank you, Your Honor. Dr. Beery, there's been a stipulation as to your medical qualifications. We won't go into all of your background. But can you tell us where you're currently employed?
I'm self-employed at the Osler Medical Center down the street.
And do you practice at Highland District Hospital?
I do.
And you have formerly been chief of staff there, is that correct?
Yes.
Okay. And you currently hold an elected position in the county, do you not?
Yes, I'm the Highland County coroner.
Okay. And how long have you been the coroner?
Since I was elected in 2012, so 2013, January.
Okay. Great. And how long have you been practicing medicine?
Here in Hillsborough, 34 years.
Fantastic. Are you familiar with James Gregg?
Yes.
And how did you become familiar with him?
The Highland County Sheriff's Office, through Lieutenant Detective Antonor, reached out to me, and they asked if I could offer testing.
And what kind of testing were they asking for?
Sexually transmitted disease, chlamydia, and trichomoniasis.
Okay. And did they bring Mr. Gregg to you? Did you go to see him? How did you interact?
They brought him to my office.
Okay. And did you perform, what did you do after they brought him to your office?
I drew a blood specimen.
Okay. And did you do that pursuant to whatever guidelines you follow?
The question posed to me was that a girl had been infected, and they wanted to see if he carried signs of the infection.
Okay.
So I thought an antibody test would be best because it might show positive even if he'd been treated for the infection subsequently.
Okay. So can you tell us a little bit about that antibody test? You say that it might show positive even if you've been treated. Can you explain that a little bit more?
Yeah, I drew 3 antibodies, IgG, IgM, and IgA. And IgM and IgA both will start to form in the body 3 to 4 days after infection, and they will persist for weeks to months, and IgG will appear approximately 2 weeks after infection and can persist for years.
Okay. And so I think you say that you performed all 3 of those tests.
Yes.
Okay. And I'm going to show you what we've marked as Defense Exhibit A. Can you identify that for us?
Yes, it's a Quest Diagnostics report on James F. Gregg for chlamydia trachomatis antibodies, IgG, IgA, and IgM.
And what are the results of those tests?
Negative.
So can you draw any conclusions within a reasonable degree of medical certainty from that test?
Yes, Mr. Gregg has no antibodies for those, for that organism, and therefore shows no sign of infection.
And with that, the long-term test that you talked about,
The IgG?
the IgG, that was also negative?
Yes.
And what conclusion can you draw with a reasonable degree of medical certainty about that?
That there's no evidence of infection in recent years based on this test.
And we're talking years, not just days or weeks?
Yes.
Okay. Now, you didn't perform the testing in your office itself, did you?
I did.
Oh, you did?
Oh, I didn't run the test. I sent it to the laboratory.
Okay. And so how does that work? Can you walk us through the procedure when you draw the blood and how it goes to the lab? And all
Sure. He was brought to my office by sheriff's deputies, and he was uncuffed, and I put a tourniquet around his arm, cleaned the area with alcohol, and then put a needle in the antecubital vein on his right arm, and drew a vial of serum in a red top tube, then marked it with his name, spun down the serum, and put his name in the laboratory computer, and put an adhesive label on that with his name. So there's two modes of identification, and then put it in the locked box in the back of my office, and then a courier picks it up
Okay,
and
so
takes
then
it to.
somebody from Quest Diagnostic picks it up?
Yes.
And on that report, does it have when you put it in the box and when Quest picked it up?
Not exactly. It was collected and picked up on the 16th, and they said they received it at 2 a.m., so the courier must have had several rounds to make, and then they reported it on the 22nd.
So they received it in their lab at 2 a.m. on the 17th, is that correct?
Yes.
Okay. And then you got the results back a few days later?
Yeah, that was the 16th. I got the report back in the wee hours of the 22nd of April.
Great. Now, did anything unusual happen with your specimen box?
Yes.
Can you walk us through that?
Yes, so Thursday the 16th was the last day that we put specimens in the box, and on Monday morning, my assistant, Haley Waring, discovered the box was dented, and then another box was askew outside the back door of the office.
You said the box was dented. Did it appear that the box had been completely broken open?
No.
And were you able to close that box and to secure it?
Yes.
And are you still using that same box today?
Yes.
And you don't know when that box was damaged? Sometime between when...
Sometimes between Thursday evening when I left for work, probably 5 or 6, and Monday morning at 7:30.
But we know the lab received the sample on early mornings of Friday.
That's right.
Okay. Was there any indication from the lab that there was anything wrong with the sample?
No.
If there is an adulterated sample or there's a problem with the sample, would the lab normally notify you?
Yes.
So as far as you were concerned, even though your box had been damaged, the sample itself had not been tampered with?
Right.
Okay. There's a statement on there that the testing was done in accordance with CDC guidelines?
Yes.
Okay. And so you have, you believe that you followed the protocol in doing that?
It's an approved test by CLIA. I'm sorry, yes, CDC.
Okay. Yeah.
So CDC would be concerned with diagnosis and transmission and spread of diseases, not the forensic antibody test. So it would be CLIA, which is another.
So tell us what CLIA is.
They oversee lab testing and procedures, so it's a CLIA-approved test, but not a CDC test for diagnosis and treatment of infection.
Because we're not worried about an epidemic or a pandemic here.
Right.
Okay. And that's what the CDC would be concerned
Correct.
with. Okay. So the CLIA testing, is that a certification that the lab goes through?
Yes.
Okay. And so he's negative for chlamydia and no long-term exposure to it?
That's what the test shows.
Okay.
Yes.
Thank you. I have no further questions.
Cross.
Yeah. Did you file a police report about the box tampering?
Yes.
So it was serious enough that you were concerned enough to contact the police?
Yes.
Did you also state to Lieutenant Antonor that you couldn't be certain that the sample wasn't tampered with or was intact?
Yes.
So you were concerned about that?
Concerned. Yes.
And enough to tell Lieutenant Antonor that you couldn't swear that it hadn't been tampered with?
Yes.
Okay. And you received the test, and there was just some talk about what the report says. Well, you can look at this, please. Underneath the reference range, it says, per CDC guidelines.
Yes.
Nucleic acid detection is a sample taken from the anatomic exposure site is the preferred method for diagnosing C. trachomatis. So I'm assuming the C is chlamydia?
Yes.
What are they saying there?
They're saying to diagnose, they prefer a swab in the penis to collect a sample.
So drawing blood is not the preferred way to test this.
To diagnose it.
To diagnose this, correct. And a swab in the penis, according to the CDC, is the preferred way.
Yes.
Is that the testing that Highland District Hospital uses?
Yes.
And additionally, the next paragraph, does that say that it has not been approved or cleared or approved by the FDA?
I don't see it, Annick, I'm sorry.
Okay.
It's a big paragraph, I told you.
The second paragraph here, right here.
Okay. This says has been validated pursuant to clear regulations. Use. Okay, where's the FDA part? Oh, right above it. Yes, it does say not cleared or approved by FDA.
So this is not the preferred testing from the CDC, and this test is not approved by the FDA.
Correct, for diagnosis of chlamydia. That's right.
And the preferred test is the swabbing of the penis.
Yes. Mm-hmm.
And that's the test that Highland District Hospital uses, the preferred,
Yes.
the preferred method. And is that test more preferred because it's more accurate?
It's more sensitive. So if a person were infected and they had a swab, it would pick it up 90% of the time. Whereas this test I did would be 70 to 90%. So it'd be as much as 20% less sensitive to pick it up.
So this test is about 20% less sensitive than the preferred method that Highland District uses.
Yes.
What are the treatments for trichomoniasis? Or I'm sorry, am I saying that correctly? I feel like
You did great. Just a Z-Pack typically, sometimes a shot of Rocephin.
Okay.
Yeah.
Well, that's for trichomoniasis?
Yes, that's right.
Or
I'm sorry.
chlamydia?
For the words sound so much alike. So the test we're talking about is chlamydia trachomatis. I've been saying these words forever. It's still tough. And trichomoniasis is a different infection.
Okay. Then this also is my misunderstanding. Did the test you did even test for trichomoniasis?
Not what I hold in my hand.
You didn't test for that?
No.
Okay. Are you familiar with what that is?
Yes.
What is it?
It's a protozoan infection that is common. It's probably 4% worldwide. In the Americas, maybe a little higher in Africa, less in Europe, that people get sexually and sometimes have little symptoms of the infection. So if you just check the general population, it might be 4 or 5%. Some people get symptoms, discharge, and pain with urination.
But you said they get sexually, so it's a sexually transmitted disease or infection?
Yes, that's right. Just like chlamydia, the test in my hand.
Okay. And again, the test that this lab in California performed did not test for that.
This sheet does not show that testing.
Okay. Do you know the treatments for that specific?
Yes.
What are they?
Typically flagyl or metronidazole, an oral antibiotic. It's given less often than Zithromax, which is commonly given for sore throats and things that would treat chlamydia, which is this test. The trichomoniasis is treated by a more obscure range of antibiotics. So flagyl or metronidazole would be the most common treatment.
And am I correct in saying that typically trichomoniasis is referred to as like a vaginal parasite?
That's right.
Okay. So flagyl, Tindamax, or Solisec, are those the three most common treatments?
I haven't used the latter two, but as I understand they are also used.
And those three things are typically used to treat bacterial vaginosis, things like that.
Yes.
Things that typically impact women.
Yes.
And now what are the treatments for chlamydia?
Chlamydia would be, that was what I started with, that would be like a Z-Pack or, well, that's all I've used actually. Zithromax works every time. I'm sure there's other treatments, but it's a common antibiotic.
What about doxycycline?
Yes, doxycycline works.
And the risk is mycin, so a Z-Pack.
Yes. Azithromycin, Z-Pack, that's right.
Literally what you take for a sinus infection?
Exactly.
Doxycycline, is it also used to treat bronchitis, sinus infections, things like that?
Yes.
What is, I guess we've already covered what Flagyl is used to treat. So James, as a man, likely wouldn't be tested for or prescribed any of the treatments for bacterial vaginosis, the same treatments that treat trichonitis.
No, I wouldn't think. If you had diverticulitis, sometimes the doctor will add Flagyl for that, but not of the common male ailments.
But there's a solid chance that if he went to the doctor for a common cold or a sinus infection, strep throat, something like that, he would be prescribed a
I'm going to
Z-Pack.
object to that.
This is his expert opinion.
Wait a minute. Overruled.
You can answer.
Overruled, okay. Yes.
Do you know the top 5 most prescribed antibiotics in the United States in 2024 according to the CDC?
I'll take a guess if you want me to, but I don't know.
Okay. If I told you that azithromycin was number 2 and doxycycline was number 4, would that surprise you?
Your Honor.
Overruled.
Would that surprise you?
No.
Can a person have chlamydia and have no symptoms?
Yes.
Can a person have trich and have no symptoms?
Yes.
In your expert opinion, if a 12-year-old little girl has trich, how'd she get it?
Section.
In your expert opinion, if a 12-year-old little girl has chlamydia, how did she get it?
Likewise, section.
And you said that those antibodies mean that the absence of them may mean that he hasn't had it in the last couple of years, but could it mean that he had it 3 years before that?
He could have, yes.
No further questions.
Redirect.
Thank you, Your Honor.
But I'm going to have you take over that because you are much better engineers than I am. You're familiar with medical records from Highland District
Oh,
Hospital?
my.
What's the
Yes.
exhibit number?
It's number 4. You've had probably plenty of years of experience looking through these medical records.
Mm-hmm. Yes.
I think if you refer to pages 13 and 14.
Okay, I'm at 13. Mm-hmm.
And what is on page 13?
A lot of things we don't need because the medical records are very voluminous. But let's see, the germane thing, the thing that seems pertinent, is trichomoniasis vaginalis by TMA for patient less than or greater than or equal to 14 years old, abnormal.
Greater than 14 years old?
That's what it says, greater than or equal to 14 years old.
And do you happen to know the age of the alleged victim in this case?
No.
Your Honor, objection. These aren't her medical records.
Yes, I was going to
They're
say,
the defendants.
these are the records of Mr. Gregg, so
Okay.
any question regarding the alleged female victim would be totally
Fair enough.
irrelevant.
Okay.
Because that is sustained.
Is there a test result on those in that package for chlamydia?
Your Honor, I'm going to object as well to this. These are his medical records, and Dr. Berry.
Okay. You have to ask questions that are related to him, not to the alleged victim. So,
I am asking about.
wait a minute. So, rephrase the question to make it clear that that's what you're doing.
Okay. On the packet you have in your hand, whose medical records are those? Do they say?
James Gregg.
Okay. So is there on there a result for a test for chlamydia?
I don't see it.
Try page 12.
Right, page 12, okay. Yes.
Okay. And what are the results of that test?
Negative.
And does it say what type of testing was done?
RNA amplification probe.
Does it say it was a urine test?
Yes.
And is that testing simply for a current infection, or does that carry the long-term testing that you conducted? Or do you...
Only a current infection.
Okay.
Yes.
So then the testing that you conducted is a wider ranging test?
Yes.
Okay. But it's still negative for chlamydia?
Yes.
Okay. Now, Mrs. Collins asked you about, you made a police report about the damage to your specimen box. Would that be a normal thing to do? I mean, if your property is damaged, would you just...
Yes, I would call the police.
Okay. So it's not simply because there was a specimen from Mr. Gregg?
Oh, no. I called the police before I even connected that his specimen might have been in there.
And were there other specimens in the box also?
Yes.
Okay. So it's not just this box that held just his specimen and nothing else?
Yes.
Okay. And did the lab indicate to you that any of the specimens that they collected had been tampered with or it was adulterated?
No.
Okay. No further questions.
All right. You may step down. Thank you.
Thank you.
That's Exhibit A. All right. Next witness. Pardon me?
No, she said no more.
No further witnesses? All right. Are you resting?
You're resting.
You wish to move admission of that exhibit?
From the referring mission of
Any
defense.
objection?
No.
Exhibit is admitted. All right. State wish to call any rebuttal evidence?
No, Your Honor.
All right. Counseling approach. Counsel. Sorry. That's right. Get your steps. All right. Ladies and gentlemen, that completes the presentation of evidence, and is now the duty of the court to instruct you on the law. And then after I finish this, we'll hear closing arguments from the attorneys, and then I'll give you the final instructions on deliberations. Now, the court and the jury have separate functions. You decide the disputed facts. The court provides the instructions of the law. And it's your sworn duty to accept these instructions and apply the law as it is given to you. You're not permitted to change the law or apply your own conception of what you think the law should be. Now, all criminal cases begin with the filing of an indictment. That indictment informs the defendant that he or she has been charged with an offense. The fact that it was filed may not be considered for any other purpose. Plea of not guilty is a denial of all of the essential elements of the offense, and the defendant is presumed, it puts in it, I'm sorry, let me repeat that. I'm doing it by memory instead of reading it, and that's probably not the best thing to do. A plea of not guilty is a denial of the charge and puts in issue all the essential elements of each offense. The defendant is presumed innocent until his guilt is established beyond a reasonable doubt. The defendant must be acquitted unless the state produces evidence which convinces you beyond a reasonable doubt of every essential element of any one or more of the offenses that have been charged in the indictment. Reasonable doubt is present when, after you have carefully considered and compared all of the evidence, you cannot say that you're firmly convinced of the truth of the charge. It's a doubt based upon reason and common sense. Reasonable doubt is not mere possible doubt, because everything relating to human affairs or depending upon moral evidence is open to some possible or imaginary doubt. Proof beyond a reasonable doubt is proof of such character that an ordinary person would be willing to rely and act upon it in the most important of his or her own affairs. Now, ladies and gentlemen, you're the sole judges of the facts, the credibility of the witnesses that were presented, and the weight of the evidence. Now, to weigh the evidence, you must consider the credibility of the witness. You apply the test of truthfulness that you apply in your daily lives. These tests include the appearance of each witness upon the stand and their manner of testifying, the reasonableness of their testimony, the opportunity they had to see, hear, and know the things concerning which they testified, their accuracy of memory, their frankness, their lack of it, their intelligence, their interest and bias, if any, together with all of the facts and circumstances surrounding their testimony. Applying these tests, you will assign to the testimony of each witness such weight as you deem proper. Now, you're not required to believe the testimony of any witness simply because that witness was placed under oath. You may believe or disbelieve all or any part of the testimony. You will determine what testimony is worthy of belief and what testimony is not worthy of belief. The testimony of one witness, if believed by you, is sufficient to prove any disputed fact. Each witness was subject to direct examination by the party who called them and to cross-examination by the opposite party. And during cross-examination, counsel was able to inquire to some matters did not directly relate to issues before the court. Those questions and answers are permitted for the purpose of helping you to determine credibility and the weight to be given to the testimony for no other purpose. Now, generally, a witness may not express an opinion. However, one who follows a profession or special line of work may express his or her opinion because of his or her education, knowledge, and experience. Such testimony is admitted for whatever assistance it may provide to help you arrive at a just verdict. However, as with other witnesses, upon you alone rests the duty of deciding what weight should be given to the testimony of the experts. In determining its weight, you take into consideration his or her skill, experience, knowledge, veracity, familiarity with the facts of this case, and the usual rules for testing credibility and determining the weight to be given to the testimony. Now, it's not necessary that the defendant take the witness stand in his own defense. He has a constitutional right not to testify, and the fact that the defendant not testify in this case must not be considered by you for any purpose. Now, ladies and gentlemen, evidence is all of the testimony that was received from the witnesses and any exhibits the court has admitted into evidence during the trial. Evidence may be direct or may be circumstantial or may be both. Direct evidence is the testimony that is given by a witness who has seen or heard the facts to which they testify. That includes exhibits admitted into evidence during the trial. Circumstantial evidence is proof of facts or circumstances by direct evidence from which you may reasonably infer other related or connected facts, which naturally and logically follow according to the common experience of mankind. To infer or to make an inference is to reach a reasonable conclusion or deduction of facts which you may but are not required to make from the other facts which you have found have been established by direct evidence. Whether an inference is made rests entirely with you. When considering circumstantial evidence, you may not draw one inference from another inference, but you may draw more than one inference from the same facts or circumstances. So in other words, you're not allowed to stack one inference upon another inference to reach a factual conclusion. If the circumstances create inferences that are consistent with either acquittal or guilt, then the defendant must be acquitted unless the inferences in favor of guilt rise to the level of proof beyond a reasonable doubt. In the absence of direct evidence of a person's guilt, circumstantial evidence by itself may justify a finding of guilty if the circumstances are entirely consistent with the defendant's guilt, are wholly inconsistent with any reasonable theory that he is not guilty, and are so convincing as to exclude reasonable doubt of guilt. When the evidence is both direct and circumstantial, you must decide whether the combination of the two types of evidence overcomes the presumption of innocence and convinces you beyond a reasonable doubt that defendant is guilty. The evidence does not include the indictment, the opening statements that you heard earlier, or closing arguments of counsel, which you'll hear in a short time. The opening statements and closing arguments, as I've indicated previously, are designed to assist you, but they are not evidence. Any statements that have been stricken by the court that you were told to disregard are not evidence and must be treated as though you never heard them. You must not speculate why the court sustained any objection to any question or what the answer to that question might have been. And you must not draw any inference or speculate on the truth of any suggestion that might be included in a question that was not answered. A number of exhibits have been introduced, testimony relating to them have been introduced, submitted evidence, and you'll consider whether those are the same objects, the same condition as they were originally, and determine what weight, if any, they should receive in light of all the evidence. Now, regarding the specific law, all three counts are charged under the same statute, and that is entitled rape and is numbered Ohio Revised Code 2907.02A1B. This law states in pertinent part as follows: no person shall engage in sexual conduct with another who is not the spouse of the offender when the other person is less than 13 years of age, whether or not the offender knows the age of the person. And so, before you can find the defendant guilty, you must find beyond reasonable doubt during the period set forth in each count, and that would be December 7, 2022 through December 7, 2023 is to count 1, December 7, 2023 to December 2024 as to count 2, and December 7, 2024 through December 25, 2023 is to count 3. And that occurred in Highland County, and at that time the defendant engaged in sexual conduct with another who was not the spouse of the defendant, is less than 13 years of age, whether or not the defendant knew the age of that person. So there are essential elements of rape that must be charged and must be proven in each count beyond reasonable doubt. And those essential elements are that the defendant did, 1, engage in sexual conduct with another who was not a spouse, 2, the other person was less than 13 years of age, whether or not the defendant knew the age of such person, and 3, that the offense occurred in Highland County, Ohio on or about the date alleged in the indictment. It's not necessary the state prove the offense was committed on an exact day as charged in the indictment. It's sufficient to prove the offense took place on a date reasonably near the date it's claimed. Before you can decide whether the state of Ohio has proved beyond reasonable doubt all the essential elements of the offenses with which he is charged, you must first decide whether or not this is the correct place in which the trial is to be held. The state must prove beyond reasonable doubt that all or any part of the offense charged was committed in Highland County, Ohio. Now, sexual conduct means vaginal intercourse between a male and a female, anal intercourse, fellatio, cunnilingus between persons regardless of sex, without privilege to do so, the insertion, however slight, of any part of the body, instrument, apparatus, or object in the vaginal or anal cavity of another. Penetration, however slight, is sufficient to complete vaginal or anal intercourse. Anal intercourse means penetration of the penis into the anal opening of a man or woman. Fellatio means a sexual act committed with the penis in the mouth. Cunnilingus means a sexual act committed with the mouth and the female sex organ. Spouse means a person married to an offender at the time of the alleged offense. Prosecution is not required to prove that the victim physically resisted the defendant. Now, if you find that the state proved beyond a reasonable doubt all the essential elements of the offense of rape as charged in counts 1, 2, or 3 of the indictment, according to your findings, then your verdict must be guilty as to that count or counts. If you find the state failed to prove beyond reasonable doubt any one of the essential elements of the offense of rape as set forth in counts 1, 2, or 3 of the indictment, according to your findings, your verdict must be not guilty as to that count or counts. Now, the charges set forth in each count in the indictment constitute a separate and distinct matter. You must consider each count and the evidence applicable to each count separately, and you must state your findings as to each count uninfluenced by your verdict as to any other count. The defendant may be found guilty or not guilty of any or one or more of the offenses charged. Now, if you find the defendant guilty as to count 1, and this instruction applies only to count 1, then you are to separately decide 2 additional findings. First, you will have to determine whether the state proved beyond reasonable doubt that the defendant was 16 years or of age or older at the time of the commission of the offense. Second, whether the state proved beyond reasonable doubt that the person found to be the victim in such count was less than 10 years of age at the time of the offense. If your verdict is not guilty of count 1, then you do not consider either of those issues. So that completes the substantive instructions on the law regarding the charges. And just to put your mind at ease, you will have a copy of this once I make a couple of corrections on some typos that are in the copy, and you'll have that available to consult when you are deliberating. All right. I think we're going to go ahead and go into closing argument, and then we'll take a break after the defense closing argument, and then come back and I'll make you'll hear the final argument from the state and then the court's final instructions. And that will be our last break, and at that time will be when you'll surrender your cell phones. All right, so on behalf of the state, Mr. Collins.
May it please the court, defense counsel, ladies and gentlemen of the jury. I first want to thank you for your time and attention to this very serious matter. I know that this is not an easy subject to talk about. It's certainly not an easy subject to listen to either. But we are one of the few countries that uses a jury system to decide guilt, and that only works because of people like yourselves who take your civil service seriously. And for that, I want to thank you. Now, I had 2 opportunities to speak with you, so I'll keep the first opportunity short. Then Ms. Hatton or Ms. Witt will speak with you, and then I have a second opportunity. I told you the state would prove with evidence and testimony that the defendant began raping Nevaeh Penwell when she was around 8 years old and in the 2nd grade. And those rapes continued until the last Saturday of February of 2026, and we have proven just that today. Nevaeh began interacting with inappropriate things and in inappropriate ways, things that were too grown up for her age. Her mom described them as some sexual things that made her concerned. Initially, Nevaeh wouldn't talk to her mama about it, but Nevaeh would talk to a close personal friend, Megan, and when confronted, Nevaeh told about this man, James Gragg, the defendant, a man that Nevaeh has called Daddy her entire life. That's who she knows as her dad. She talked about him penetrating her with both his fingers and his penis. Now, while it's hard to find any physical evidence when a child waits to disclose sexual assault, physical evidence does exist in this case, and it exists in the form of the sexually transmitted infections or diseases, they're one and the same, that the defendant passed on to Nevaeh. Delayed disclosure isn't Nevaeh's fault. Remember, this man is telling her that no one will believe her, and that she couldn't see her puppy Sweet Potato if she told what was happening. You know from the testimony and from the evidence that Nevaeh tested positive for chlamydia at 12 years old, and she tested positive for which is short for trichomoniasis, also a sexually transmitted disease at 12 years old. You know from her interview with the Mayerson Clinic that was recorded and played, she was asked if anyone else had touched her, and she said no. The only person who has touched me is James Gragg, the man that she calls Daddy. You've heard about the sexual assaults Nevaeh faced from her own mouth. You've heard from other people that she told about the abuse. You've heard from a past girlfriend whom also contracted an STI from the defendant. You heard from the expert in child abuse and forensic interviewing who interviewed Nevaeh about the abuse. You heard from a doctor that tested this defendant and found the more rare STI. And finally, you heard from Detective Antonor, who has investigated so many sexual assault cases. And all of these people have said the same thing, that this man raped Nevaeh repeatedly over the course of 4 years. Ladies and gentlemen, you have the testimony, you will have the evidence, and you have a job to do. Find this man guilty of all counts. Thank you.
All right, Ms. Hatton.
Thank you, Your Honor. Ladies and gentlemen, thank you for being here this afternoon, all day today, actually. Mrs. Collins is right. This is a very difficult case, or difficult discussions that we're having. Whoever thought I'd be standing in a room full of people discussing chlamydia? I mean, it's just not something that we would normally do. So I thank you for your patience in listening to all of this. I do want to point out that there are several inconsistencies. Jessica Adams did not testify that she got chlamydia from James Gragg. She may have testified she tested positive for chlamydia, but she also testified that she and James Gragg broke up in 2023 and that she's seen other people and been intimate with somebody else since then. So there is absolutely zero evidence that she contracted chlamydia from James Gragg. Mrs. Collins also cross-examined Dr. Beery on the testing that he did. And there was a discussion about the best form of testing. It would be a penile swab. I won't go into how that is done. Leave that to your imagination. But also that the Highland District Hospital report, their testing, which was also negative for chlamydia, was done by a urine sample, not a penile swab. Dr. Beery's testing was a blood test where he tested for 3 different things, all of which were negative for chlamydia. He tested for an active infection, he tested for a recent infection, and he tested for long-term. And there were no long-term antibodies, which would indicate that Mr. Gregg has not had a chlamydia infection in the last, as Dr. Beery said, several years. He did not have an active infection. He had not had a recent infection. And I think that that is very important. It makes me weep to think that this 12-year-old child has an STD, or 2 of them. STD, STI, VD, whatever we want to call it. But what is clear is that she did not contract chlamydia from James Gregg. And the question that raises is, where did she get that? Which in my mind makes me believe that there is somebody else out there who is interfering with this child and may continue.
Objection to facts that are not in evidence.
There's no evidence of that, so I'll sustain that objection, and that is to be stricken.
The facts are clear that she did not contract chlamydia from James Gregg. We don't know where she got it because the state did not introduce any evidence of where she got that. But we know that he doesn't have it and hasn't had it, not for years, or as far back as there's no evidence he's ever had chlamydia, let's put it that way. When Nevaeh testified today, she testified that James told her if she told anybody she'd never see her puppy sweet potato again. But you also watched the interview that the Meyerson Center did with her a couple months ago. And she was very clear with Stephanie Helton that nobody had told her there were any consequences. She talked about her dog. If James Gregg had told her, don't talk about this, that would have been the time to say when she was talking about her dog. But Dad said that I wouldn't get to see my dog again. But she didn't. In fact, quite the opposite. Said, no, nobody told her there were any consequences. Her testimony, both with Stephanie Helton and today, was that she alleges these things took place in James's home, in his bedroom, on his bed. Repeatedly. I don't understand why somebody would continue to go there and go to his bedroom and get in his bed if this was happening. You need to ask yourselves that. Is this something logical that would happen? She also testified multiple times, both she mentioned several times with Stephanie Helton, and she testified today that she's told many lies. She told too many lies were her words. I hope that she's not lying about somebody interfering with her. Because if she has been interfered with, then I want that person brought to justice. But also remember that she herself has admitted that she's told too many lies. And whether she is lying about who has committed these acts. In her interview with Stephanie Helton, she several times mentioned that James Gregg never touched her with his penis. Now, we heard Officer Antonor say that sometimes there are incremental disclosures, but she was pretty adamant about that with Stephanie Helton. No, never touched her. Her clothes were on. And if that is true, how did she contract these diseases? Not from James Gregg. Once again, think about how else that might have happened. She stated her clothes were all the way on. Dr. Terpstra testified that you can't get it through clothing. That it's through sexual contact, but not through clothes, not through toilet seats. So think about these things and the inconsistencies and the things that just don't make sense about this case. And ask yourself, is it really that likely that a man who does not have chlamydia passed chlamydia on to his child, or is there somebody else out there? Thank you for your time.
All right. We'll go ahead and proceed. Close. Yes, go ahead.
A few things I just want to address from Ms. Hapner, what Ms. Hapner just said. The first is that Dr. Berry actually did not testify that he never had chlamydia. What he testified to is that he hasn't had it in the last couple of years. I specifically followed up with him and said, does this test mean that he's never had it? And he said no. I said, when you say the past couple years, like past several years, past couple years, past couple years. And we know from Nevaeh's testimony that she's been sexually assaulted by the man for at least about 4 years. So 4 is more than a couple. Most people look at a couple as 2. So there's always an interesting thing to consider when we consider how a 12-year-old child who's being sexually assaulted should act. They should tell what's going on. They should not put themselves in the position to be sexually assaulted again. We're actually blaming her for going back and being sexually assaulted. That's what this is. When we say, think to yourselves what she's doing going back over there if this is happening to her. Well, this is Dad. I mean, this is the only dad that she knows. This is the man that she calls Daddy. And are we really going to blame a 12-year-old little girl for going over to see Daddy? Is it her fault? Absolutely not. It is his fault, period. It's never her fault. Now, there may have been things during this trial that were mentioned that weren't developed, that left questions in your mind. But be mindful of the judge's instructions. There are often legal reasons for what we are allowed to share and what we are not allowed to share with you. As the judge has instructed you already, and as is in your jury instructions, the evidence and testimony to be considered in this case is the testimony that you heard from that chair and the exhibits that you will have to review back in the jury room. In considering the testimony and evidence, it's important to remember that nothing the defense attorney said in their questions is evidence. Only the answer is evidence. Now, as Ms. Hapner touched on, one of your main jobs as a jury is to test the credibility of the witnesses. And you use the same test for credibility. We talked about it in voir dire, the same test for credibility that you use in your everyday lives. Think about the manner of testifying, their reasonableness, their opportunity to see, hear, and know the things they're testifying about. Look at their accuracy of memory, their frankness, their lack of frankness, their intelligence, their interest in bias. You take all of those facts, you consider them, and you decide whom to believe from that witness chair. Let's apply it. We're going to talk about a few things that the witness has said today. You heard from Nevaeh herself, and the defense is going to great lengths to talk about her inconsistencies. And she said she was a liar. She called herself a liar. And you can't believe anything she said because she's called herself a liar. Well, number one, she's a 12-year-old little girl today. An 8-year-old little girl when this started. And the man that's doing this is the man that she knows as Dad. Period. There's no worse position to be in. She talked to you about this today. Now keep in mind that just as you don't know her, she doesn't know you, and she sat right there in that chair and told you about the most embarrassing moments of her life. Are those the actions of somebody that's lying? Wouldn't it be easier to say, never mind, I am not telling the truth because there's no way I want to talk about this in front of other people. I don't want to talk to 12 perfect strangers about my period or about bleeding or about the 2 STIs that I have. Those aren't things that a child lies about. There's no benefit for her to lie. The benefit is that she gets on the stand today and has to tell everybody in here about it and then be subjected to cross-examination and then talk about it some more and then be called a liar. What's the benefit for her to lie? There is none. They want you to believe that because she said, I've lied before, I didn't know anybody would believe me, that she must be lying now. But let's talk about those lies. I asked her, I said, what were you lying about, Nevaeh? I was told I wasn't allowed to use the phone and I would sneak it and use it anyway. My heart beat still. Well, she's a 12-year-old kid. Yeah, they lie like that. Did the dishes. But I really didn't do the dishes. I cleaned up my room, but I really didn't. So you're a liar? No. Those are the actions of a child. She's a kid. You heard from Dorothy, Nevaeh's mom. Again, she was open in her testimony. It subjected her to talk about her personal life and things, and she's no bias. There's nothing to gain or by testifying today. You heard from Jessica Adams, who was previously in a relationship with the defendant. She tested positive for chlamydia. She did not have any sort of testing done from the time that she was with the defendant until February of 26, and was with only one person in between there, other than the defendant. She came forward to tell her story today, even though, again, she's embarrassed by this. This isn't something that people want to climb up in this chair and talk about. Stephanie Hilton, the expert from the Mayerson Clinic who specializes in forensic interviewing of children who are the victims of sexual and physical abuse, was the next witness to testify. She's been trained on the correct way to interview a victim, and there's no allegation that she did not follow those rules. She was forthcoming and frank about her interview with Nevaeh and the things Nevaeh told her. She's no interest or bias. There isn't extra pay for her if he's convicted or not. She is simply doing her job. You heard from Dr. Terpstra. He ordered the testing of the defendant for the sexually transmitted infections and reviewed the findings. He explained those findings to you, that this defendant tested positive for trichomonas, which is a sexually transmitted infection. It's more rare than chlamydia, and the only way that Nevaeh would have gotten the infection is if she had been sexually active. Now, there was a big discussion about what sort of testing was done and this and that, and Dr. Berry, there was no indication that he had ever reviewed the medical records for the defendant from Highland District Hospital, so put him in a bad position. But you will have these medical records. And he explained that the preferred method of this testing is a penile swab. That was their expert testimony. And if you review the medical records, page 13, which is what he testified about, swab. And then you look at
I'm going to object to that, Your Honor. That's not what the medical record says. It says canceled. The testing was canceled.
All right, you have to correct that. That's good. All right, come here. Let's see what you're looking at.
So, page 13, order of comments, penile swab, the preferred method that their expert talked about from Highland District, that's the method that was completed. You have the medical records, you guys are reviewing for yourself. You also know that the test that the defense, or I'm sorry, the test that Dr. Berry performed was not a test for both trick and chlamydia, but only for chlamydia. That was his testimony. Now, finally, you heard from Detective Vinnie Antinor, and again, Detective Antinor, no interest or bias. He just related the facts and evidence as he collected it and followed it. He's just doing his job. Now, there is physical evidence in this case, and there is a substantial amount of circumstantial evidence. The physical evidence are the medical findings. Again, even their expert witness says the only reason a 12-year-old child has trick or chlamydia is because there's been sexual intercourse. That was their expert's testimony. That was our doctor's testimony. Again, this defendant also tested positive for trick. Jessica Adams, who was previously in a relationship with the defendant, tested positive for chlamydia. The only thing that Jessica Adams and Nevaeh Penwell have in common is a sexual relationship with this man. That is strong circumstantial evidence that this defendant gave both Jessica and Nevaeh chlamydia. Don't fall, I'm sorry. Now, again, let's talk about the first test that Dr. Berry did, and it was negative. Remember, first of all, that the testing box, this is Dr. Berry's testimony, was tampered with, and his testimony today was that he couldn't swear to the validity of the blood or the test. When reviewing the test, he saw that the procedure used is not the preferred method by the CDC, and the testing procedure is not FDA approved. And it was his recommendation to Lieutenant Antinor that a more accurate method of swabbing the inside of the defendant's penis be done. He's the one that described the test that should be done. When the medically approved and more accurate test was completed, the defendant was positive for trick. They next made an issue with the fact that Nevaeh tested positive for chlamydia and the defendant did not, so someone else must have been touching her. Well, not necessarily. Let's think about their expert's testimony. The 3 antibiotics that are commonly used to treat chlamydia, the number one, according to their expert witness, is a Z-Pak. So the same thing a person gets when they go to urgent care for a sinus infection or for strep throat or a bad cold. It is the second most prescribed antibiotic in the United States, and it treats chlamydia. Now, the antibiotics that treat trick are more commonly given to women because trick is associated with bacterial vaginosis, not something that the defendant is going to go to the doctor and complain about, or anybody. It's not something that you walk into urgent care and get a Z-Pak to treat. Very specific antibiotics, according to their expert, treat trick, which is why it's not commonly treated easily. While chlamydia, you might have no symptoms, go to the doctor for a sinus infection, have chlamydia treated that you didn't even know you had. It's not that far-fetched to think that he was treated for this, maybe didn't even know he had it, when you realize from their expert that the antibiotic to treat it is a Z-Pak, and the second most prescribed antibiotic in the United States. Prescribed to treat everything, except for trick. And again, the defendant's expert, in his expert opinion, stated that this child got these STIs from sexual intercourse. Now, they want you to believe that because she initially said that he tried to put his penis in her and she fought, but has now disclosed that his penis did go in. Well, she's a liar. Those are inconsistencies. Well, remember the testimony not just of Detective Antonor, but of the state's expert witness, the witness who does forensic interviews and does this for a living and is an expert in forensic interviewing, says it is very, very common for a child to disclose a little bit and then a little bit more and then a little bit more. She's in therapy. She feels more safe. She feels more comfortable. Delayed disclosure is a lifelong journey. It's not uncommon. That's what the expert that specializes in this said. So it's not an inconsistency that now, well, initially she said no, there was no penile penetration, and now she says yes, there was. That's not an inconsistency. That's a child who is feeling safe enough to fully disclose what this man did to her. Again, that is not an inconsistency. It is a child who is making a lifelong disclosure of sexual abuse. And again, I want to remind you that we're talking about a 12-year-old little girl talking about the most embarrassing thing in her life. When Nevaeh was only 8, her life became truly a hell every weekend. A man whom she considered her daddy, who was trusted to protect her, took her innocence. James Bragg, this defendant, took away Nevaeh's sense of safety. He used her love for a puppy named Sweet Potato to sexually assault her. He allowed her to believe, no one's going to believe you. When he was told that she was bleeding for 27 straight days, that's not a big deal. We don't need to worry about that. Of course that was his reaction. I want to talk about the elements of the crimes alleged and the evidence and testimony that proves each of these crimes. Remember what we talked about in voir dire. If I don't prove the temperature on the day it happened, it doesn't matter, because only the elements of the crimes have to be proven. If I don't prove what color socks the defendant was wearing when he raped Nevaeh, it doesn't matter, because the color of his socks are not an element that you're going to read about in your jury instructions. So starting with count 1, rape of a child under 13 and under 10. In order to prove rape, the state must prove that during the period of December 7th through 22 and December 7th of 23 in Highland County, Ohio, the defendant engaged in sexual conduct with 8 or 9-year-old Nevaeh Penwell, and this occurred in Highland County. Now, remember she told you she remembers being in the 2nd grade because she had a really awesome teacher, Miss Rowe. Miss Rowe was pregnant, and they did a gender reveal, and she did a gender reveal for the class, and Nevaeh talked to you about that today. So, in the 2nd grade, she was 8 to 9 years old from 2022 to 2023. We've proven this element. And down here, Nevaeh was less than 13. She was 8 or 9 years old because she was in the 2nd grade. So we've proven that as well. She said this occurred at the defendant's house, and we know at his trailer, and we know from Detective Antonor that the address of that trailer was 6690 Golden D Lane or Golden Doubloon Lane in Hillsborough in Highland County in Paint Township. It's over by the lake. So we've proven this element of the crime in Highland County. So the only element left to prove rape is that the sexual conduct occurred, and you are going to have this instruction in your jury instructions that looks just like this. Sexual conduct is defined as the insertion, however slight, of anything in the vaginal opening of another. I believe it's on page 6 of your jury instructions that the judge gives you that specific instruction. There's no question here. When the defendant entered the bedroom, put his hand down Nevaeh's pants when she was in the 2nd grade, moved her penis to the side, and inserted his fingers into what she calls her vaginal hole, causing Nevaeh pain. He committed the crime of rape. That's sexual conduct right there. The insertion of anything, however slight, of any part of the body, so his fingers, into the vaginal or anal opening of another. penetration, however slight, is sufficient to complete vaginal or anal intercourse. He's done that. We've proven sexual conduct. We've proven that Nevaeh was not his spouse. I had to ask her that question if she'd ever been married to him. We've proven each element of count 1. Now, when you look at your verdict forms, there are 2 additional findings on count 1. The first says, we further find and specify the person was or was not under 10. We know she was under 10 because she said she was in the 2nd grade. She was 8 to 9 in the 2nd grade, and that was between 22 and 23. So after you find him guilty, yes, she was less than 10. There's also a finding that he was older than 16. Well, the testimony was that his birthday was in 1982. This happened in 2022. The testimony was that he was around 40 years old when it happened the first time. Well, that's definitely older than 16. So, yes, he was older than 16. Please pay close attention to those and make those extra findings on the verdict form. Count 2, rape of a child under 13. I'm not going to go through all these again because we just proven them. On her docket period of December 7th of 23 to December 7th of 24, you know that she was 9 to 10 that year and in the 3rd grade. She talked about things that happened to her specifically in the 3rd grade. We've proven that element. Again, we already know that the addresses in Highland County that happened to this house. We know that sexual conduct is defined as the penetration or insertion, however slight, of any part of the body into the vaginal opening. Again, we know that he did this knowingly. We've already defined sexual conduct. She talks about other times that he used his fingers, times that he used his penis. We know that they weren't married, and we know that she was less than 13 years of age because, again, she was between 9 and 10 in the 3rd grade. Again, he is guilty of count 2. Count 3. And count 3. Again, the same charge, but a different time period. Now she's in the 4th grade. During this time period, happened in Highland County. Again, we've already proven this. We already proven sexual conduct. Again, she talks about being there, having her eyes squeezed shut, hearing him take his belt off, and the belt hit the floor. Like she knows the sound of the belt being taken off. She pushes him off. Now, we know from her medical records that she wasn't always successful, and we know from her testimony today that he put his penis inside of her. So again, we've proven sexual conduct, the insertion of anything, however slight. We know they weren't married, and we know that she was less than 13 years of age because go over to the chart. In that year, she's 10 to 11. Again, Nevaeh told you about, and the medical records prove that this defendant inserted his penis into Nevaeh, passing along STIs. STIs that 2 medical professionals today said no 12-year-old little girl should have. Nevaeh remembers that she had her period for a long time after he inserted his penis into her. Dorothy remembers that as well and didn't realize what was going on. She spoke to the defendant about this because he's dad, so they have a talk about this, and he says, "It's not a big deal. Don't worry about it." Yeah. Now the defense wants you. I'm sorry. Covered that. Nevaeh. The state must prove each and every element of the crimes charged beyond a reasonable doubt, and it is the highest level of highest standard of proof in the law. But it's doubt based on reason and common sense, and you equate this to your own the decisions that you make in your own lives. Let's talk about buying a car. You shop around and you collect the evidence. It's no different than sitting on a jury. You want a red SUV and you find one. The odometer says 50,000 miles. The payments will be about $350 a month, and your budget allows for $400. Everything that you want in a car. All the evidence points to you buying the car, and you decide to buy it. Now, there is some remote possible doubt that this is not the right car for you, but reasonable doubt based on reason and common sense, has been overcome and you decide to buy the car. It's the same thing here. Doubt based on reason and common sense has been overcome, and this man is guilty of raping this little girl. The state has done what we said we'd do. We said we would prove each element of the counts of rape, and we have proven each element beyond a reasonable doubt. And I told you that I'm sorry that you've had to sit through this case. I know it's not easy to listen to, but it's necessary because there is evil in this world and evil in this room. And I'm asking that you go into the jury room, read the instructions, review the evidence, remember the actual testimony of the witnesses, and come to the only conclusion that makes sense. Find the defendant guilty of repeatedly raping Nevaeh and of his evil actions. Thank you.
All right. Ladies and gentlemen, that concludes the closing arguments, which again, on structure and all evidence, are simply an expression of the attorney's view of the case. Now, we're going to take a 10-minute break, and I'll make the final changes in instructions and then come back to give you the final instructions on deliberations. When you come back, we'll go to the jury room. You need to leave your cell phones in your car, or we just collect and put them on the sill above the heater there before you go in the jury room, because there are no electronic devices permitted in the jury room while deliberating. If you need to make a call and tell somebody that you're just going to deliberations, you can do that. Again, if you do discuss, say anything about that, don't tell anybody what the case is about, or discuss the matter in any way. So we'll take 10 minutes, and so when you come back, then you can put your phones in when you go into the jury room. You don't have to do it then, or you can do it whenever you want to. All right, 10 minutes.
Please rise.
Please. All right, ladies and gentlemen, it's now time for the instructions of the court regarding your deliberations. You must be uninfluenced by any consideration of any sympathy or prejudice. It's your duty to carefully weigh all of the evidence and decide all of the disputed questions of fact, to apply the instructions of the court to your findings, and to render your verdict accordingly. In fulfilling your duties, your efforts must be to arrive at a just verdict. Consider all the evidence and use your common sense to make your findings with intelligence and impartiality, without any bias, sympathy, or prejudice, so the state and defendant will each feel that their case has been fairly and impartially tried. Now, you may not discuss or consider the subject of punishment. Your duty is confined to deciding the guilt or innocence of the defendant. In the event you make a finding of guilty, the duty to decide punishment is placed by law upon the court. You may have observed during the course of the trial the defendant's in the custody of the sheriff's office. That's not an indication of his guilt or innocence. It simply means he was unable to post the bond the court required during dependency of this action. We may not consider that fact that he's in custody for any purpose. If during the course of the trial the court has said or done anything which you consider an indication, in my view, of the facts of the case in general, you're instructed to disregard that. As a judge, I must be and do desire to be impartial in presiding over this or any other case. A court does not have the right to invade, nor can it invade the privacy of the jury, and the rulings the court's made do not indicate a preference as such. Now, your initial conduct upon commencing deliberations is a matter of great importance. It's not wise to immediately express a determination or to insist upon a certain verdict, because if your sense of pride is aroused, you may hesitate or to change your position even if you later decide that you may be or you are wrong. Consult with one another, considering each other's views, and deliberate with the objective of reaching an agreement, if you can do so without disturbing your own individual judgments. You must each decide the case for yourself, and you should do so only after discussion and consideration of the case with your fellow jurors. Do not hesitate to change an opinion if you find that it's wrong. However, you should not surrender an honest conviction in order to be congenial or to render a verdict solely because of the opinions of the other jurors. When you go to the jury room, your first function will be to select one of your number as a foreperson. The person you select will preside over your deliberations, but does not have any greater power, nor does that person's vote have any greater importance than anyone else's. Foreperson serves the purpose of helping you to conduct your deliberations in an orderly manner and give each juror an opportunity to express your opinion. One additional duty of the foreperson is to see the verdict forms, exhibits, and copies of these instructions are returned to the court after you've reached your verdict. Now, as I said, I'll place the exhibits and the verdict forms in the possession of the jury. The foreperson will retain those. Now, until your verdict is announced in open court, you're not to disclose to anyone else that the status of your deliberation is more the nature of any verdicts. Now, this being a criminal case, before it is said that you can be said that you've reached a verdict, it's necessary for all 12, I repeat, all 12 of the jurors to agree upon a verdict. Now, you'll have with you in the jury room, in addition to these instructions that the court has submitted, the exhibits court has submitted, a copy of these instructions, 3 verdict forms. Each of these have the case name and number, and have a verdict, and it's count 1, count 2, and count 3. And each of the verdict forms read, we, the jury, having been duly impaneled and sworn, find the defendant, James Franklin Gregg, and then there's a blank space, and that is where you will insert your verdict, and there's a reminder of that below there, and it's either guilty or not guilty. Of rape, first-degree felonies, he stands charged in count, in this case, count 1, and in the others, count 2 and count 3. And then if, as I indicated in the instructions, you find the defendant guilty on count 1 only, then you will consider 2 additional findings regarding that count. Again, it only applies to count 1. And that is that you further find and specify the person involved was or was not under 10 years of age at the time of the offense. And the second additional finding is that the defendant, we further find the defendant was or was not 16 years of age or older at the time of the offense. So each of those have the was or was not, so you'll just circle whatever your finding is to indicate that. Now, once you've reached your deliberations, once you've deliberated and reached your verdicts, then you'll complete the verdict forms, and all 12 of you will sign, because again, it takes all 12 of you to have a verdict. And then once that occurs, you'll notify the bailiff. Now, bailiffs, once you retire and leave your cell phones out the door, you'll be under the charge of the bailiffs, and one of them will be stationed outside of your door at all times to ensure that your deliberations are not disturbed. However, bailiffs are not permitted to discuss the case with you or to answer any questions about the case. So if you do have any questions or other needs, please write them down, knock on that door, and give them to the bailiff, and then after the court has reviewed them with the attorneys, court will respond in writing. Now, I can't promise you I can give you, I can answer your specific request, but I will respond to you. So, for instance, if you ask the court for a question about something that is factual, such as, what color was the car that was driven was driven to the scene? Well, I can't answer that because the court can't do that. If there's evidence about the color of the car, that's just a hypothetical. Then the jury has to make that decision, and if there's no evidence of it, the court can't provide it. So what I'm getting at is I can't provide you evidence, any additional evidence. If you ask for more evidence, I can't give it to you. Now, once you've reached a verdict and filled out all the forms, knock on the door and inform the bailiff that you've reached a verdict, and then he'll report back to the court, and I'll have the parties reassemble as quickly as possible to return you for your deliberations, or for your verdict's announcement. Now, is there anything further from counsel?
No.
Okay. Ladies and gentlemen, I want to thank you for your patience, cooperation, your attentiveness during this case. You've been very attentive. It has been a relatively short trial, so we've obviously did everything to not waste your time, present the case efficiently, and I think the attorneys have done a good job with that. Now, at this time, the alternates, Mr. Crown, Mr. Link, you're not going to participate in the deliberations since, fortunately, nothing's happened to any of the other 12. But you will still be subject to being recalled if, during deliberations, something should happen. So we'll ask you to provide your phone numbers to the bailiff, and then once a verdict is reached, we will have you contacted and tell you that the verdict has been reached. And at that time, then, you are released from the instructions that I've given you. But until that occurs, you're not to discuss the matter with anyone, try to find anything else about the case, read anything about the case, anything of that nature. And I can tell you that twice in my career I've had to bring alternates in when something happened during deliberations. One person fell ill. Another case, there was a reason that person was not permitted to continue. And so we had to bring an alternate in. So it does happen, not very often, but that's, again, you guys are our insurance policy. Just make sure that, everything that we've done doesn't fall apart if something happens to one of the other jurors. So if you would, you could be excused at this time. Come over here and give the bailiff your cell phone numbers. And then, ladies and gentlemen of the jury, that you would then retire to the jury room, and then I'll send back the exhibits and have one more correction on the jury form, instructions, and then you go ahead and proceed. Go ahead. You can run one back. Counsel? I just noticed. I didn't count one person involved. So, or the big one, I should say. So I said first. Here's copies of the instructions as they went back to the jury. Okay, we're back on the record. I just want to correct one thing. We were off the record when I was talking to Mr. Collins, Ms. Hapner up here. On count one, I had the additional finding that it said the person, and I changed that to the victim. And then it was pointed out that the findings are in reverse order from the instructions, so I just reversed them on the form to conform to the instructions. Is there any objection to either of those things?
No objection.
All right. All right, then we're ready to go. All right, so here's the verdict forms and the revised instructions. Thank you. Be seated. All right. I'm informed by the bailiff that the jury has reached a verdict. So, around if you would bring the jury in, please. You can see it. All right, record will reflect that the jury is now in the subject courtroom, and Mr. Dicker, you are the foreman. All right, as the jury reached a verdict on all three counts,
Yes.
you would hand the verdicts to the clerk, please. All right, Mr. Hodson, would you please read the verdicts?
Court of Common Pleas, Highland County, Ohio. State of Ohio versus James Franklin Bragg. Case number 26CR49. Verdict, count 1, rape. Revised code 2907.02A1B. We, the jury, having been duly impaneled and sworn, find the defendant, James Franklin Bragg, guilty of rape, a first-degree felony, as he stands charged in count 1 of the indictment. We further find and specify that the defendant was not 16 years or older. I'm sorry, you're right. Sorry. Was 16 years or older at the time. In the Court of Common Pleas, Highland County, Ohio.
There's another finding. There's two findings.
I see it. Thank you. We further find and specify that the victim was not under 10 years of age at the time of the offense.
Was. This circle. Was.
That's what I said. When did I say?
Yeah, you said was.
Did I say it wrong again?
Yeah, was.
Sorry.
Yeah.
So that it was on both.
Yes.
That's what we got. Okay. Should I read those again, or are we okay?
Yeah, go ahead and read it again just to be clear.
We further find and specify that the defendant was 16 years or older at the time of the offense. We further find and specify that the victim was under 10 years of age at the time of the offense. Okay. Court of Common Pleas, Highland County, Ohio. State of Ohio versus James Franklin Bragg. Case number 26CR49. Verdict, count 2, rape. Revised code 2907.02A1B. We, the jury, having been duly impaneled and sworn, find the defendant, James Franklin Bragg, guilty of rape, a first-degree felony, as he stands charged in count 2 of the indictment. In the Court of Common Pleas, Highland County, Ohio, State of Ohio, versus James Franklin Bragg. Case number 26CR49. Verdict, count 3, rape. Revised code 2907.02A1B. We, the jury, having been duly impaneled and sworn, find the defendant, James Franklin Bragg, guilty of rape, a first-degree felony, as he stands charged in count 3 of the indictment.
All right. Thank you, Mr. Hodson. Ladies and gentlemen of the jury, you've heard the reading of the verdicts and the additional findings on count 1. Are these the verdicts and the additional findings of each and every one of you as to each count? All have indicated in the affirmative? Does either party wish to have the jury poll?
No, Your Honor.
No, Your Honor.
All right, then the court will accept the verdicts of the jury and enter findings of guilty as charged as to all three counts. All right, ladies and gentlemen, that will complete your service for this case, and also for the rest of the term. You'll not be subject to be summons for another trial. If by chance that should happen, just call in and let us know. It doesn't normally happen, but sometimes computers are only as good as those of us who use them, and in my case, that's not very good. But in any event, that's the case. Now, you are discharged from your in the instructions that I gave you before, so you are free to talk with the case if you wish. You don't have to. That is strictly up to you. I want to thank you for your service. These cases are always difficult, and the topic of this one obviously was difficult, but everyone did everything that they needed to do, and we appreciate your service in performing the civic duty, which, as I indicated this morning, is extremely important for us in this community to enjoy the rights that people have died for us, and so your service today has certainly continued that tradition. So I want to thank you. You can be excused this time. Get your phones if you don't have them already. And Mr. Hodson will see you downstairs with your pay vouchers and any work excuses you may need. Thank you very much. All right, please be seated, everyone. All right. Court will go ahead and proceed with sentencing. The defendant hasn't been found guilty on all three counts. I do need the sex offender registration form. I need one of those. I'll go ahead and fill it out if you haven't done it yet.
We have not done that yet. Oh, these aren't good. I might have one in here.
All right, I'll go ahead and start with that explanation. And I think I can remember most of it, and I'll go through it. You have the form there, Mr.
I do, Your Honor.
Just bring it on up.
Complete
I'll take care of
form.
it. Yeah.
You just need one to read off of?
Pardon me?
You just need one to read off of?
Yeah, thank you. All right. So, Mr. Gregg, you've been convicted of 3 counts of rape, which are Tier 3 sex offender, child victim offender registered offenses. That means that you'll be required to register as a sex offender if you should be released from prison for the rest of your life. You will be required to register in person with the sheriff of the county in which you establish residency within 3 days of being released and going into that county, or if you're going to be there temporarily for more than 3 days. You're also required to register with the sheriff of any county in which you might establish a place of education immediately upon entering to that county. You're also required to register in person with the sheriff of any county in which you are employed, and employment includes community service or volunteer work. And if you are employed in that county for more than 3 days consecutively, or more than a total of 14 days in a calendar year. If you establish residency, education, employment in a county in a different state, then you'll be required to register either with the sheriff or the public official or law enforcement agency that is charged with the monitoring of sex offender registering in that state. You're required to provide the sheriff of your county of residence with any information at any time that you are going to be gone temporarily for 7 days or more, so that if you're on vacation or if you're going to be staying with family or visiting family or something of that nature for more than 7 days, 7 days or more, then you're required to let the sheriff know of the information regarding the address of the stay in that county. Now, you're required, if you change your residence or replacement of education, you have to provide an advance written notice of that with the county of your residency registration or education registration 20 days before you change it. If you change your county of employment, you have to register that no later than 3 days after the change, since you are entitled to do 3 consecutive days in a year, or if you had more than 14 days in a calendar year, then you'd be required to report that as well. If at any time you should not have a fixed address, you'll be required to provide a detailed information of the place or places you will be staying, and no later than the first business day immediately following the day you obtain a fixed address, you're to register that with the sheriff. You're required to provide written notice within 3 days of any change in your vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you with the sheriff or sheriffs and with whom you've been most recently registered. According to under federal law, you're required to report any international travel to your registering authority or authorities not less than 21 days prior to travel, and that could subject you to criminal prosecution under both federal and state law if you fail to do that. You'll be required to confirm your information, verify your information every 90 days in person. Can't be done by phone, internet, or mail or any indirect contact. It must be in person, and you cannot do that more than 10 days prior to your verification date. Now, in the event that you fail to verify your residence or changes in notice of your residence or any other information that's required under the law, that could result in a criminal prosecution, and you could be found guilty, could be sentenced to prison for violations under Chapter 2950 of the Ohio Vice Code. Since your current residence is in the was Highland County, right? All right. Since your residence currently in Highland County, that would be the anticipated release. And so, if that is the case, then you're required to register with the sheriff of Highland County at the Justice Center, Homestead Avenue. What's that? 130 Homestead Avenue
Yes, Your Honor.
in Hillsborough. All right, and then you have the form there for him to sign. All right, bring that up, please. All right, so the record is this your signature on here, Mr. Gregg?
Yes, sir.
All right. And the court will sign this form. All right. And I'll proceed with sentencing. On behalf of the state, Ms. Collins.
Thank you, Your Honor. Your Honor, under count 1, the state is of the opinion that the sentence that is to be administered is life without parole. She is under 10 years old, and that's the accepted sentence at that age, or for that specific charge. Count 2 and 3 would be 10 to life based on the age of the victim. And I want to point out, I'm not sure if the court remembers this defendant or not, but in 2016, we had a trial.
I did.
Okay. So it's pretty obvious to me that this is the kind of defendant that the life without parole statute was exactly intended to protect the world from. If he is allowed to be out, he is going to keep doing this. He's not been out of prison very long, and Nevaeh looked at him as a daddy, and he did this to her. So I would ask the court to impose the maximum sentence against this man, because I have no doubt that if you don't, he'll do this again. And, Your Honor, I believe that someone from the family does this.
All right. Just state your name for the record, please. All right, go ahead.
My name is Paige Gregg, and I am speaking on behalf of the victim, my little sister. The defendant is my father. However, he is not my sister's biological father, but he is the only father she has ever known. How could the same man who rocked her to sleep as a baby, who played with her as a toddler, and who was supposed to be her protector, become the one she needed protected from? It's something I ask myself every day. The trauma she has endured at the hands of the defendant will stay with her for the rest of her life. She will have to find a way to cope with what happened to her at the hands of the person she called Dad. After she came forward, she was terrified to even leave the house or have the front door unlocked out of fear that the defendant would find out she told someone about the abuse and come for her. The fear that she felt went away upon learning that he had been arrested and could no longer hurt her. The mental and emotional burden she carries is a heavy one that me and every single person who loves her will carry alongside her forever. On behalf of my little sister, I ask that the defendant receive the maximum legal punishment.
All right, is there any other representatives or the victim that would like to speak?
No, Your Honor. Thank you.
All right, anything else from the state?
No, Your Honor.
All right, on behalf of the defendant?
Thank you, Your Honor. Your Honor, I understand that Mr. Gregg does have a prior criminal record for a similar but not as serious offense. I understand that count one does carry up to life without parole. We would ask that you not impose life without parole, but the 10 to life that the other counts carry. Thank you.
And it's agreed to count the sentence on the other two are 10 to life.
Yes, Your Honor.
Mr. Gregg, is there anything you'd like to say?
No, sir.
Well, Mr. Gregg, you went through this same experience 10 years ago. You had a jury trial. You were found guilty. You were sentenced to 54 months for gross sexual imposition. I believe the victim in that case was also under 13.
She was under 13, yes,
That's
Your
what I
Honor.
thought. The charge is under 13. Here we have a repeat. If you're not an example for a life sentence without parole for a sex offender, I don't know who would be. You've had a previous conviction, and now you've brutalized and her as well, your stepdaughter, and changed her life forever. And it's, she's doing a lot of things to try to deal with that, but the trauma that you cause is just unimaginable and simply detestable and just cannot be overlooked. So it is the judgment of the court that you be and are hereby sentenced on count one to a term of life without parole, since the victim was under 10 years of age at the time, and because you have previous sex offense for a victim under that age. In the court's view, you pose a serious risk and danger to any child, female child, given your history, and therefore, as to counts 2 and 3, you're sentenced to a period of 10 years to life on each count, and those are going to be ordered to be served consecutively to each other, as well as to count 1, even though it's a life without parole sentence. In the event that there should be some change in the future to that, these two sentences are 10 to life. But they are also to be served consecutively. Now, the reason for that is, again, as I said, you're a repeat offender, you're victimizing children, and it's clear to the court that you pose a significant risk of committing the same offense again, should you ever be free. And therefore, it's the court's view that the sentence that is to be imposed should do everything that's possible under law to make sure that you're never free to roam the streets of our community or any other community, for that matter, to put children in danger. The sentences are not disproportionate to the seriousness of your conduct. Again, even though it's one victim, there have been multiple offenses, and the harm that you caused to her is mental anguish, and the trauma she'll be dealing with for a long time, if not forever, for the rest of her life, is such that it's necessary for this punishment to be the sentence. And again, these were committed as part of a course of conduct, and that the harm is so unusual that one single prison term for any of the 3 offenses would not adequately reflect the seriousness of the conduct. And again, your history of criminal conduct, not only in sex offenses, you also have a burglary conviction and some other convictions, but I know that was a felony. And so that demonstrates clearly that it's necessary. Do we have a jail time credit?
Yes, sir.
Okay. Now, you'll be given jail time credit on that. Looks like the arrest date was April 16, is that correct? All right, that is 119 days. All right. Now, upon, in the event that you should ever be released from prison, certainly as to counts 2 and, well, most likely that would be on parole. So I don't know that there's no post-release control, is there, because everything's parole on counts 2 and 3.
We agree with that.
Yeah.
That is,
Yeah.
so.
All right. So I don't believe that post release control would apply. Do you have anything to the contrary, Ms. Hapner?
No, I believe that was pre-Reagan hoax. So.
Okay. All right. Now, you're also ordered to pay the court cost, which judgment is granted in execution's order. If you fail to pay the cost, those can be collected by the clerk through various means, including levying on bank accounts, wages, earnings, or other assets that you may have. All right, now, Mr. Gregg, you are entitled to appeal the verdicts and the sentence of the court. You must, if you do want to appeal, you must file that notice of appeal with the clerk within 30 days of the entry of your sentencing being filed, which will probably be tomorrow. And you have a right to have the transcripts of the trial and any papers that have been filed in the case, or transcripts of any other proceedings to assist you in pursuing that appeal. If you do not have the money to pay for those, the court will provide those to you at no cost. You have a right to have an attorney to represent you in this matter, and if you don't have the money to continue, or on the appeal I should say, and if you don't have the money to continue or to pay them, then the court will appoint counsel for you. You will need to fill out another application, financial application, to show that you have that. Now, you can talk to your attorneys about whether you wish to appeal or not. Typically, attorneys anymore don't handle, the trial attorneys don't typically handle the appeal. That's a matter of preference for most attorneys, but some attorneys do, so you can talk with your attorneys about that. If they don't want to handle the appeal, they could, though, go ahead and file a notice of appeal on a limited appearance for you, just to preserve that right, so the court would then go ahead and so if Ms. Hapner or Ms. Witt, if you decide to do that to protect his rights, appeal, just make it a limited appearance for that purpose only, and then the court will appoint an attorney to represent him if that's what he wishes.
Yeah, I indicated, Mr. Gregg, that I will file the notice of appeal for him, but I will also ask the court to appoint separate counsel for
Sure.
him.
Okay. All right. Is there anything further, counsel?
No, Your Honor. May I approach?
You're remanded to custody.